What's up, guys? Sorry, I was getting everything together. I got my coffee. So, yeah, I don't expect a bunch of people in here. Truth is, I was just bored out of my mind, and I saw that shit going on, and and yeah, I wanted to hang out with people and talk about it. I'm gonna go ahead and just play from when he was cross-examining his ex, which it's so horrible that he gets to do that. I mean, it's his right. It's just, and I'm not implying that right ever be taken away from anyone, but I just really feel bad for that ex having to put up with that. I'm not going to go through the whole questioning. I'm just going to like fill time until they come back from lunch. What's up, Tina Sewer?
Alleged incident on
Callie Dime, Fit and Curvy, good to see you again. Beastly B. Hernandez, Diggs, Amanda Page.
There's been no contact between you and
Michaela Payer.
Not since then, no.
So, Brenda, did you get your...
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming that would mean no contact at all via phone or anything like that.
No.
I hate your ass too, Teddy Jedi.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. It's not proper.
Look, they're astonished. Like, they're like, did this dude just like flash evidence that was never submitted? Ultra Dark CEO, thank you so much.
They have no relevance.
Now, again, this is not live,
Yes,
folks.
Sustained.
This already happened.
They've also never been disclosed to the state.
It is. I know, Teddy Jedi.
Sustained.
Sustained why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well.
Can you see this guy like just
that
brainstorming
there's been no
this tactic, this strategy, right? Just sitting around brainstorming like,
the alleged defendant being,
oh, I'm gonna drop a bomb when I get her on the stand. Ooh, without like filing any type of motions or submitting any evidence properly.
grounds.
Sustained. Assumes facts not in evidence. Not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and at
facts.
this point,
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
See, now
For
You're
the record.
correct. After the date charged, that the dates that are charged.
we only get like a glimpse, really, when you think about it, into his mind. Like, when you really think about it for a second, we're only getting a glimpse into this dude's mind because we're only getting what he lets us see from the stupidity that comes out of his mouth and the craziness that comes out of his mouth. But we're talking about, allegedly, of course, even though there's photographs, pictures proving, but talking about a guy who just like mowed over people like they were nothing at a parade where people were happy, just having a nice day, having a nice time. And he just mowed over these people like they were nothing. And then, so you got that part right there, right? There's the alleged domestic violence that took place. There's all of this stuff, right? So these things are just a glimpse because we're also looking at somebody who we would assume is a liar and a manipulator. But here's the thing is I think he's absolutely lying about this letter that he starts talking about. I think he's absolutely lying about it. I don't think that she wrote him letters in jail. I don't think I think the prosecution, whoever this new addition is to the prosecution, is like awesome because he's not putting up with anything. Like it feels like he's been watching this from home and he's just like, I'm so sick of this. Anything that I can do to help, I'm getting in on this. I mean, obviously he's not watching from home. I'm just saying it just kind of comes off that way. Obviously, like he's working and helping put together this prosecution and helping put an end to this case behind the scenes, probably working really, really hard.
For these allegations, you are absolutely correct.
Thank you.
Right. That's what I'm thinking, Donna, because the prosecution basically points it out because they wouldn't say they have proof of a phone call, of a jail phone call, you know, unless they had it. They're not stupid. They're not going to say they have proof and not have it like this guy's doing.
The evening of November 21st.
Jody Lynn, thank you.
2021.
He's loving he had control of her to shame her. Right. Yeah, I agree with you.
Have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
She doesn't even want to look him in the eye, and I don't blame her.
I'll rise for the jury.
I mean, you are entitled to your feelings on that. Absolutely. Everybody here is entitled to their own feelings, whether you disagree with each other or not. Just please be respectful. But that's a touchy subject. A lot of life. And I'm not even sure if I disagree with you, or you know what I mean? I'm not even sure if I disagree with you. I would have to really think about that.
Let you make an offer of proof as to why
I'd have to be much more educated to put up an argument on that, and I'm just not.
Contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of?
That's
Now
not
you see how defensive he just got?
the door.
Hear me.
See, if we're going by true crime rules on how to judge somebody's body language, like we're true crimes, we're true crime followers certified to experts on body language, right? But one thing we always hear, right, is when someone's lying, they cross their arms like that in defense. You never see an attorney do that in court. You almost never see that. Like when you really think about it, you never see that. And for him to get all defensive and cross his arms like that is interesting, especially when making this claim.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said
translation.
in such a way.
These witnesses have done an incredible job not spitting in your face, not screaming profanities at you. These witnesses, all of them, have been incredible this whole time. Every time I've seen a testimony, I'm just like, wow.
A way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts of evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not,
yeah, it makes me sick too,
or
Rose.
why she wouldn't have contact or not, you are opening the door to that testimony.
How
All of my rulings
does-
have
how
been
does-
made to prevent
how
what
does
could be
speaking
seen
work?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get
Have
on
you
the
turned
stand and
that
lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Wow, that's very professional.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so that- so
document?
what-
Hold on. When did
Wait.
I'm having you make an offer. When did you receive the
Okay,
document?
but that I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist.
He already
that I
knows how
have.
close he is
That's
to
not
getting
true.
booted
That's a
too.
mistake.
No,
Statement of the
that is
evidence.
true.
No.
She said it herself.
No. Marking an exhibit is not creating an
No,
exhibit.
not marking an exhibit. She said
We're not
that
going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
All right.
fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
It's
y'all
like he
I
has
wanna
no
see the
concept
letter.
of the
With
word
I want to
proof.
see the letter.
It's
Okay,
insane.
so I gotta-
And I wanna
so now
know
I gotta
when you
bring that in.
received it.
Now I gotta bring that in. Every time this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir, there are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a rule.
Please, dear sweet baby Jesus. Please, dear sweet baby Jesus. Please let the 43rd time that Bullhorn Betty gets arrested, she decides to plead not guilty and represent herself in court. Please, because it's going to look just like this. I guarantee it.
A
It
ruling.
threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks,
Come on, man. Stop.
when you
Stop
aren't
Stop
even
it.
letting
You're a
me
public
ask
Wow.
servant, Your
questions.
Honor. I respect your courtroom. I
You
respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You
Wow.
stated
So
yourself.
he's look at the patience on this poor woman, bro. Because he's basically saying, you work for me. That's what he's trying to do. He's trying to establish dominance like a narcissistic, abusive piece of shit that he is over a woman. And he's trying to say, you work for me. I'm in control of this courtroom, not you. He just knows better than to say that out loud. That's how you know that he is being manipulative over just being stupid. Like, he's stupid, but he's very, very, he's conscious of what he's doing, though.
Yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson to be excused?
Yes, you can be excused.
See?
My apologies.
Big ups
My
on this
apologies
dude
too,
right
but
here.
it needs
Big
to-
ups on that dude right there for speaking up and saying, all right, let's get this witness out of here. Like, she should not have to be subjected to having to listen to this guy be abusive towards women. She broke up with him. She's earned that right. Now he's in jail and on his way to prison. She does not need to listen to 1 second that is not absolutely necessary of this guy being a complete and total abusive douchebag.
Needs to be some truth, especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay.
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly.
Oh,
today.
I know I'm
have
right on
shown
this,
an
Margot.
abundance of patience.
On this, I know
morning.
I'm right.
I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you
One second, guys. Sorry about that. I hit the wrong thing, yo. There we go.
from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
Telling her what to do. I love it.
The
We're moving
document
on because I'm saying we're
that
moving on.
Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count and they have prosecutorial discretion. And I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's a
Right. Like, it's a charge against you, dude. It's a count against you, and the prosecution dropped it. And here you are arguing about that.
an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My
Your Honor,
guess
Your
is
Honor,
maybe
with
to
all respect.
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
I tried, yeah, and I've been trying to find it ever since I came back in here. Now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make
You
the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I
Wow.
appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents. I don't know what happened. Things of that
Yo,
nature. When
if-
you came back out, you took
If I'm married to this lady, y'all, like, I'm like, I would go to hell if I am anything short of the most catering husband of all time, assuming that she has a husband. The most catering. Like, I would have a file cabinet in memory of I would be building a file cabinet of memory of every meal that she's even remotely liked. And I would have one ready for her every night when she came home. I would have a hot bath ready to go for her, like with whatever the hell scents and shit that you guys put in there to relax. Candles. I would do anything it took to like relax this poor woman after the day that she has had every single day. Every single day. If that husband is not doing that, he's a douche. That guy sucks. And I mean, I'm not saying that because she's, you know, attractive, I guess, but I'm saying that in the sense that, like, anybody having to put up with this and behaving the way that she has been handling this, like, she deserves to go home to the most accurately simulated version of heaven that a human being could ever simulate.
It took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't say
You implied it, sir.
But did I say that?
Oh my God, dude.
I
You
never
stated
said
it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone
With a-
out
with-
though.
and like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
words
what
to
I
that
said,
effect.
but I did not point the finger at anyone.
So
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir.
Lex Lux.
It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering
And
me.
I
with
love that she's
questions
finally
or
calling him out on
comments,
this.
statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction.
There you go.
Away from what we're doing, perhaps even to stall and to delay.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
Wow.
So-
That's a big word for you, Dad.
I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a
Now,
witness.
Margot, I said this last time I went live about this. I personally agree with you. But during that live stream, I actually had an attorney in here and she explained it pretty well. What she's doing is basically, in layman's terms, she is avoiding any chance of him appealing on anything. So she kind of has to do this. I didn't think she did. But this attorney was like, yeah, it's infuriating to watch. And her name is Mystery Maven Esquire, by the way. So go ahead and subscribe to her. But she's an actual attorney, and she was in here explaining, like, it's great when I have an attorney in chat. There's also Our Lady Justice, I think her name is, that comes in here. I don't think she has a channel, but she comes in here and she's also an attorney. But she stays anonymous, but she seems to know exactly what she's talking about.
Yes. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right. Then there's the statute on bias, 90616. All right. And none of the questions, as I heard them, went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether
This trial
it
is
has
going to take
relevance
forever,
to
man.
those issues. Number one, when did you receive this letter?
I received this multiple letters actually over a period of time. It wasn't, I referred to this one because this one had the pictures. But
And why do you
So
believe it
when
was
she
from
removes
Ms.
him from the
To answer your
courtroom,
question
because
with
when
clarity.
they come back from lunch, I can almost guarantee that's going to happen because she just about did it this time. But when she does remove him from the courtroom, how does that work? Because I haven't seen that yet. Like, can he, like, is he like on, like, you know, Zoom or StreamYard, or, you know, where he's like, where she can mute him if he's doing what he's doing now? Because, like, if that's not in violation of his rights, why not just do that? Just move on with the trial and just mute him. You know what I mean? Like, because you can't, that shit doesn't fly anymore. There was a time where you could, like, actually have a bailiff gag the person who was acting like this, but that doesn't fly anymore. But it's not a violation of his rights in my, I would imagine, I don't know, but that, you know, she puts him in another room and he has to, like, video conference the whole thing. Just like during COVID, everybody did that. All trials took place like that during COVID for a minute there. So, like, why not? You know what I mean? And just mute him.
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter. I brought the pictures because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need the
knows that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It
Right.
goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, "Oh, I wonder how you're doing," and oh, this and this and that.
I
Oh,
don't think
you know,
she's
I still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that, but I don't believe she
But
ever said that. She specifically said today when you asked her, why
See,
did you?
he knows what he's doing, people. Like, those of you that think he's too stupid to be manipulative, that's what he's doing. He's basically kind of creating this narrative to destroy her credibility, saying that she claims that she's afraid of him, but if she's so afraid, why is she writing him letters in prison or in jail? Why is she doing that? But he can't provide any proof that she has. He's just got these pictures.
It was either why did you go back or why did you have? I'll look at my notes. And she
It was
said,
why.
I don't know.
It was why weren't you forthright with all the details?
Because I'm guessing that the prosecution,
So-
called her up to basically reiterate the point that he's dangerous, that he's a dangerous person, someone to be in fear of.
Again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
You're
relate
right.
to her
Yeah, he's
credibility before
totally
the
doing
jury?
that.
Who else could these pictures be from?
Who else could
I'm
the
going to
pictures
ask you
be
point
from?
blank. Did you get a letter that's signed from her?
I got. What do you mean sign? No
How
one
do you know?
signs letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are-
it the content
are you
of the
kidding me?
letter? No, I'm not kidding you. I need
Okay,
to make a record.
but let me just, for the record, say, folks, that I have never in my life written a letter to somebody and sent it through the mail without signing it, without saying from this person or love this person or sincerely this person. I have never, ever, ever not done that. And this guy goes, who signs a letter? Everybody. Like in grammar school, where you're actually taught how to head a letter, how to indent. In grammar school, where they teach you that, the final step is to sign. And that's when they start teaching you how to create your signature.
Records are, you're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position.
And
You've
yes,
never
and
been in
date it,
jail.
Kimmy 71.
So you've never received a letter from someone writing someone in jail. No one is gonna.
It doesn't matter where
When you
You're
say
not
to
the
me-
answering my
recipient
question,
is.
sir.
It-
What's the basis why you believe they're from Miss Patterson? Is there some information?
The only reason somebody would not sign a letter that they sent someone in jail is if they were using it to sneak drugs or contraband in. That's the only way they wouldn't sign a letter.
in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying,
Why
could
would
be anybody
somebody?
else.
Shannon Marie, thank you so much. He literally just said that he was missing the letter. It was gone. Now he said he didn't bring the letter. Seriously, what the fuck? He can't even keep his own story straight. Yeah, I agree. Totally.
You got to answer my question. It's
Your
called an
Honor,
offer of
this-
proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters.
Why would
sir.
anyone
That
else
might
know
be
her handwriting,
your own
though?
testimony. So that I'm trying to figure out why you believe they're from her.
This is a guy, okay, this is his way of thinking, folks. This is a guy who doesn't understand that he has to provide something like proof, okay? But he seems to understand that the prosecution has to provide proof in order to convict him. In order for him to get convicted, they have to provide proof. And he seems to have this great knowledge, even beyond knowledge of what proof is, to the point to where he's even trying to say that his name being in all caps does not prove that that's actually his name. This is the way of thinking that he is, but yet he doesn't seem to understand that what he has to do is that there's no way that anybody, the jury, the prosecution, nobody is going to go, well, okay, if you say that that's her writing the letter, well, then that's good enough for us. That's insane. It's insane. He is completely lacking a sense of self-awareness. It's very, very narcissistic.
all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know.
I have
There's an
not
offer of
spoken to
proof.
a flat earther.
Are you
I would
serious?
love to
What do you
speak with a
believe-
flat earther.
Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like, how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has
So
to
he's
be- it has-
perfectly capable of questioning any proof that the prosecution provides, yet he can't seem to understand the concept of it doesn't prove anything that she wrote you these letters if you're just saying that she did.
it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter.
It has to
So
be
if you're
put in a
gonna
legal
question her
term or
on that,
something.
The state absolutely has a right to see the letter.
Yeah.
So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
Right.
So
The
what
state
about,
has.
You got to have the
ability
letter. This
to
is all a moot
question
point until you
about
provide
that,
the letter, buddy.
question this witness and to look at the veracity of what your claims are here. So when I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
Exactly, bro. Show some receipts.
Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
In
You
a
know,
different way.
sometimes, sir, I don't hear what you say because you interrupt me so much
Mm.
or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In a
that just
quiet
fine.
courtroom,
And
yes,
everybody
we can
assumes,
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic. where you
Because
try to
it's not a
go
tactic,
off
it's
of what we're
facts.
I love that
talking
she's
about
finally
to
calling him
some
out on
other
it.
reason.
Like, at
facts.
least call him
Because
out
I
on
find
it,
it
right?
hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have two pictures that you believe were from this witness.
that I know is from
No, that you believe.
that I know?
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before.
Mm.
Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods,
Boom.
about Dawn Woods sending these photographs.
You see how quick they got that? Because they didn't know nothing about those pictures. Just a few minutes ago, they didn't know nothing about those pictures. And somebody that they're working with behind the scenes in that prosecutor's office is doing some digging. They've got a cherry back there. That's what they got, a cherry back there, and they're like, yo, check it out. Boom, 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 boom. Sent you a jail phone call that was gonna shut this picture bullshit down right now.
To him. Now,
That's a lie.
about Dawn Woods. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie, though.
three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom.
Listen
I think
up.
That's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
Boom.
And that's
Furthermore,
I object to that
I'm not
because
done.
that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door.
is being
We can
loud.
open the door.
Somebody's
on how
taking
old
this
I told you she
personal.
was when we met.
Interrupting.
We can ask
He's-
that
he
question
is
too then.
over
Yeah,
the
people
top
don't like being
and
called
in
sex
my
offenders,
face. Mr.
especially
Brooks,
sex
I'm
offenders.
ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the
All
record.
right, under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just gonna take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he
Don't
can
sit
show
there and try
it
to
is
think you know what's
inadmissible,
going
she will
on.
not be questioned. And under 906.11, I will
Then you gonna
declare
talk
the
about what my
cross-examination.
kids did. You don't know where-
closed.
you don't
That's
know where-
awesome.
what
Thank
happened
you.
at
We're
the
in
time for
recess,
all this
1
happened,
hour.
bro. Get your facts straight.
That's
So
awesome.
let's open the door on all of it.
Act like a
Get all of
thug,
it on the
yell
record.
and scream, and
Since you
call
think you
people
know so
bruh
much.
in a courtroom when you're on
Did you know
trial
she
for your
said
life.
she's 18 when I met her. Did you know that?
And now it's muted. Are they back yet? Let's get all the way back here. Oh, he's in another room. Let's get.
So
Hold
did
on.
you make your record?
I did. From my perspective, the questions that were
All right.
actually asked and answered. We are on day 15 of trial, and today has been a rough morning, to say the least. We are in the stage of this trial where Mr. Brooks has.
There's
the
an
right
echo. That's
to
not me.
present
That's on their
relevant
end.
and
Sorry
probative
about that.
evidence and to call witnesses. And I have done my very best to honor his rights in that regard. Part of this morning dealt with his, from my perspective, disagreement with how I yesterday and in the days preceding that set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, excuse me, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly, my obligation under 906.11 to make sure that there is an effective presentation of evidence.
Okay. I have to point out,
And
folks.
exercise reasonable.
She just put him in a room where he is segregated, meaning he's alone, and he's got a mask on now. Now he's got a mask on. Not when he was in a courtroom full of people just now, an hour ago. But now he puts on a mask. Okay.
Reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record.
Now, I'm sure there's a
the
guard in
full
there.
Language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following.
So what I'm
Making
guessing the
interrogation and
echo,
presentation effective for the ascertainment of
the echo is his mic is on and he's not wearing earbuds like me. If I wasn't wearing earbuds, you guys would probably hear an echo too.
truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct
And yeah, you
examination.
guys are making
The
great
next section,
points.
leading questions.
So he gets to hear this, I mean, he's in defense of himself. He is defending himself legally, right? But this is very telling as to what his intentions here are by defending himself. Because if he thought and believed that he was actually going to get away with this, he would be listening to everything that she's saying. He would be listening to every word. He does not want to hear anything. He just wants to disrupt. He only wants to disrupt. And since he is not currently in a position to disrupt, he chooses to ignore. He chooses to throw a little silent tantrum and read. I guess that's the Bible. Some of you guys are saying that's the Bible in the chat. But he's reading and not paying her any attention at all because he can't be heard now.
Leading questions should not be used on the direct examination of a witness, except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial or even a motion hearing.
This is cleanup time now.
And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair,
You
to
have
be unbiased, to protect
more.
the rights of
More.
not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course,
Miss Buddy.
last but not
Miss
least, the
Buddy.
jurors. Prior to the court taking an early lunch this morning,
Well, Austin, the jury
couple
was
of
not
things
in the
happened
room
that
when
I
they
think
said that.
are worth making a further record.
That's a good
about.
point,
Going
but the
to
jury
beginning of this
wasn't
morning,
there,
Where it is true.
when they went
I
over
did
that.
not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively.
See, Bama News 101,
for
he's
all of
not
the
crazy.
reasons that are stated in 906.11.
He's got
And
psychological
I thought it was reasonable
issues,
at the time to simply take
but
up
he's
issues
aware of
dealing with
everything that's
legal
happening,
matters at a break.
and he's
That's
aware
why I
enough
brought
to
the
try to
jury in.
manipulate it.
During the jury coming in, Mr. Brooks continued to talk, make statements. The record
Which makes him
speaks
malicious,
for
by
itself.
the way.
I'm not gonna, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom.
There you go.
He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down.
I don't like to say the names that I see on Cash Apps, but someone just sent me a Cash App, and I just want to say thank you for that. Because it's not always the same handle that I see here, and I don't recognize that handle. So just to not dox anybody, I just want to say thank you for that Cash App. I really appreciate it. I don't know why that just happened. There we go.
Down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay,
Yep.
and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal.
There you
if
go.
He is convicted. I brought him, I should state it this way. He is not in this courtroom presently because on day 15 of this trial, And specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common
I agree,
courtesy,
Grace.
I think that just as a human being, we all would expect have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic.
It's coming
For
off
example,
like
just today, when the issue came up about this letter that he
thank you,
claimed
Tatted Jedi. I
was
appreciate it,
sent to
buddy.
him by Erica Patterson, and I asked repeatedly for
See, I'm getting the impression here, folks, that he's not coming back into the courtroom for the remainder of the trial. At this point, everyone's sick of it, and they're going to move forward. She's saying, I've tried my best to be fair. She's giving all the reasons for the record, by the way, for the record. She's giving every possible reason why he is no longer allowed in the room.
for an offer of proof rather than
In the
answer
courtroom,
the
rather.
question directly. Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of
Ultra
the
Dark
issues that are
CEO.
before this court.
Cherry stepped away, Ultra Dark CEO, but I'm pretty sure that my Cash App link is in the description. But I really appreciate it. Thank you. And thank you, Teta Jedi.
And then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate
I
description of
totally
what is
agree.
happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder.
Oh,
He got
appreciate
more
it, Tata Jedi.
disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted, so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question? Basically, is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other act's evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on 2 separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to
Thank you
not
so
run afoul
much.
of the court's prior ruling.
Um,
That leads to the evidence.
I just got another Cash App, but that had somebody's real name in it. So whoever you are, thank you very much. I very much appreciate it.
Claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906.16 and 906.08. Those are generally 2 of the statutes dealing with character evidence. That would be 906.08, 906.16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding
Julie
whether he
Porter,
sees
I
the
don't
child
know.
on or off, where they met, things of that
I don't
nature.
think so. I mean, I'm sure it would help
Solely
the
to
case,
attack
but
her character, sorry,
Ultra Dark CEO,
as a
thank
mother,
you, man.
which is
Appreciate it.
wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906.16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erica Patterson, and then the photos. The issue as it relates to this witness is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were
Yeah, they put
objected
them on
to
timeout,
by
Sherry,
the state and
so
then
that she
by
can
the
get through
state.
this.
Mr.
But
Brooks would open
this
the
is not
door
live, so I'm pretty sure that they brought him back in the
to what
courtroom by
only
now.
could be described as very damaging
But
evidence
I
against
was
him,
under the
related
impression that the
to
purpose
the
of
other
this
act's
was just
evidence,
to
related to
uh,
whether he has a relationship with the children or not, and frankly, a topic I am not going to open the door.
I thought
to,
that was just to
not
get
going
him
to allow.
to
It's
basically
a
justify
side
for the
issue.
record that he's
It's
not
not
allowed in the
relevant.
courtroom anymore. But
It is
I
not
think he's
probative.
actually in the courtroom live now. But this is not live because I keep pausing and talking over it, whatever.
But certainly, one could argue
Tana Jedi
based
kiss my
upon the
ass. One of these
questions.
days I'm going to learn OBS.
topics that the door.
I'm
could
going to
be
learn how to
opened
use it. I'm
to.
too old and boomered to know how to computer, but I'm going to learn OBS and switch to that.
It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson.
Got you.
When they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong. That needs to include an offer of
Thank you
proof
for sharing
as
that
to
link, Cherry. I appreciate it.
why he believes this letter is from Erica Patterson and why it's relevant to the issues in this case. Because he came in to the courtroom this afternoon and is not in here, but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants
I agree.
must be
Fuck
given
Frank.
sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom.
There you go.
Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it.
Finally.
I would remind him once again of SCR Chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them do unto you. Be respectful. Be kind. Give these proceedings the due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the record for that momentarily.
He's searching all those boxes for the
An
letter
offer
that
of
does
proof
not
if he
exist.
wishes to do that related to the letter and further questioning. I also want an offer of proof.
But she
as
did
to what
say,
probative and relevant information.
she did say before when she was arguing with him that that he showed her the letter. So, I mean, according to her, Now, I don't know if he just held up a piece of paper, was like, I got it right here. I don't know exactly the details of that, but she did say that he showed her the letter.
Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? October 7th, I believe she was.
Yeah, no click in prison is going to like
We did
adopt
not
this guy. He's not
glean
going to get
anything
any sympathy
new,
from anybody
probative,
there.
or relevant through the course of
Nobody's going to claim
the
him.
questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence.
All right. So let's get.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the
I just said no. I just said that.
All right, thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were you going to question her about?
She threw him out before, yeah, but he's back in the courtroom.
I guess I'll have to look in here because so much that happened since over the past hour and a half or so. I can tell you one thing. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I don't remember her. What do you mean by related to her direct question? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to prevent relevant and probative evidence. But under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already
Oh my
covered.
God, dude.
What, to pursuant to the police report or something? Is that what you're asking? I don't
I'm
understand.
asking you.
Oh, thank you
Once
again.
again, sir, give me an offer of proof as to what you believe your questioning.
Ultra
will
Dark
be as
CEO.
to
Thank you so
Ms.
much. You were way
Patterson
too generous
going
today. I
forward.
really appreciate it.
And you said related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police report. That was the last few questions. That's why I'm saying it was only.
Is it a statement that she wrote?
I don't know
Cherry,
if it's a statement that she
we
wrote.
don't allow
Do you see a- do
profane
you see a
fucking
written
terms
statement
like
with her
knob in
signature?
I'll have
here.
to go through all the
Okay.
paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about, so I know?
You guys are
it's
killing
specificity?
me in this chat, dude.
Oh, I'm looking at it now.
You guys are like psychic because what you're doing in my
How
chat,
many
this little
officers- how
game that
many
you're
officers
playing,
did reports? 'Cause it
I
seemed like it's more than
troll
just two.
Cherry in DMs this exact same way. I just
At
spam
least from
her
this paperwork,
just
it's
because I get
more than
bored.
two.
Just- Oh, you guys are fantastic. That's gonna be fucking pissing her off right now.
Mr. Brooks is referring to, I can maybe help him try and explain, but
There's like no way you guys
know
would
what
know
you're
that
talking
I do that too. It's so funny to me.
I can't find the first page.
Oh, I have the best chat ever.
so I've got
Jerry, I had nothing to do. There's
pages
no way they
2
could have
and
known
3
that.
out of 6 from Detective Barrett's report under Waukesha Police Department incident number 21-047533. This is one of the 2 reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
I'm telling you, like, there's no way. It's way too elaborate, Cherry. There's no way. Like, even, I mean, I'm a good troll, but I'm not that elaborate. There's just no way that I.
Brooks, I trust that you're
What do you
prepared
think that I
and you
like
know witnesses.
private
So
messaged
what
all these people
questions-
and like
what
got them?
about
And
that report you
I
wanna
created this
question Ms.
conspiracy to
Patterson
troll
about?
you.
Your Honor, I just stated 3 times I would have to read a
Yo,
little bit
Frank,
of this.
what's up,
to form
dude?
the
It's
question.
good to see you.
Under my authority, under 906.
Ted and Jedi would disagree,
And
but
given
you
that
know,
this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness.
you're right.
out on
It
a
is
witness
kind of
stand
my
when the-
style to
and
do
then
something
we'll bring
like
the
that,
jury
but
out, and then I will
I
simply ask the state if there are
I'm too
any
lazy.
questions, and then we'll move on from there.
Just so I understand, what do you mean by close?
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
Boom.
How do I, first of all, the report isn't even in order. So I would have to essentially read at least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof.
Yep.
So I'm bringing the witness out. The jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I
then
have
if
to do
can't-
that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your
So
right
I might
to
as
be
well
present.
have just
No
stayed over
such
there.
contempt finding.
I might as well.
He
have just
did
stayed
time
over
him
there
out,
if I
Cherry.
was gonna be
Mr.
held in
Brooks,
contempt.
that decision is for you.
When he
and
comes
you
back,
alone
I'm
to
giving
make,
him a
and it's
wrench.
based on your
It's
conduct.
fucked up,
If
Ted
you're
and
gonna
Just
Jedi.
take me over there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're
a mis-
attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal?
That's me, Tata Jedi. I'm Vitrol, according to
Why am I
Cherry.
being
Mr.
held in
Brooks?
contempt?
I'm
That's
gonna
the-
keep
that's
you
the
in
whole-
here because
that's the
there's-
whole
you're
reason
gonna
I
need
didn't
to
wanna
call the
come-
next witness, and I'm gonna need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here, because you was gonna find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I want
Obviously
you
you
in this
do.
courtroom.
So here we go. Okay. Yeah. In other words, I'm going to the other room, but not because you say I gotta go, because I want to go. That's that's the translation here.
Courtroom.
Obviously you do. You brought it up before we can even get to.
All right. Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though it will be
did I
short,
actually forfeit that right?
You
have
did.
forfeited your right to be present.
It's on the record.
And
Yes.
how
You
did
were
I
like-
forfeit that right, Your Honor?
All right. We're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding you in contempt.
Then what did I
Frank,
do?
come on
I'm
back.
going to step off. You've interrupted repeatedly. I'm going to step off.
Tata Jedi, I am putting you in the other room for the remainder of this live stream. You will have your wrench back when it's over. You're on your misuse of the wrench has forced me to put you in the other room for the remainder of this stream, sir. So yeah, to answer your question, I'm quicker. So Frank, yeah, come on back, dude, and and Geek Room will have a wrench when you come back.
Decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further.
You don't know me, apparently, not even Cherry, because Cherry knows damn well I'll take her damn wrench for the remainder of this stream. I'm bold like that. I'm bold like that.
Further make the record when the record.
Oh, that's right. You guys have like a
speaks
group
for
thing, Tata
itself.
Jedi.
You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now, you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case.
It's like a child. I don't want to
I will
ground
advise
you,
you
but
that if you are in that courtroom, because I have put you there and you have not reclaimed
I'm not this judge, Cherry.
the right to be present,
I
by
don't
number
have
one,
to
asking,
be.
and then
You can appeal all you want.
expressing a willingness to conduct yourself consistently
just do
with
it to make
decorum
a
and
point.
respect inherent in the concepts of courts and judicial proceedings, you will remain over there.
As a matter of fact,
And it looks like he took his headphones off, so I would.
you have a seat for 300 seconds, Cherry.
Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
She's trying to say something to me. Yeah.
What you trying to say?
That was very
Oh yeah,
disrespectful,
Cherry is my
sir.
right hand.
You chose to take off your headphones. You
Yeah,
choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
God
Well, I
damn
would think
it.
your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And
You
you
don't
are
gotta
not,
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir.
This is amazing.
Who is your next witness?
First of all, is she talking to me again?
Yeah, she's talking to you, dude.
We gotta keep doing this little childish stuff, dude.
Oh my God.
I gotta sit
He's
up
saying
here
this
and I'm
child. Oh
supposed
my
to abide
God.
by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
There you go.
to
There you go,
answer
Judge.
This court don't have
Get
no-
him.
no integrity.
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to
You
present
can't do that.
any
Show me what-
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that is law. That's all I'm asking. Show me that is lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay.
gladly bring you back into this courtroom so you can present your additional witnesses.
Your
But you
Honor,
need to ask me to come back into this courtroom.
with all due respect, I'm tired of having this back and forth with you every day.
Oh my God. He did not just say that.
And have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I
Nah, you don't get to
understand
plead
something, I'm
ignorance
going to
on
ask
this
the
one,
question.
buddy.
I apologize if it makes you feel that I'm intentionally trying to delay the proceeding. If I'm
Yeah, it's
intentionally
not
trying to
me.
be disruptive,
It's the
because that's not the case.
and even though he's got headphones on, I don't know why there's an echo, but it's not me.
Disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset.
Like
And I
at this
just want
point,
you
she
to
doesn't give a
understand
fuck what he's saying.
It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. It's not up for debate.
Then why are you bringing it up?
Control what's going on
Everybody
here.
knows that
What's
but
going
you.
But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited
It doesn't matter what you
in Illinois
interpret though.
versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt. If
What's
I'm-
the
if
third,
I'm not
Mr.
under-
Brooks? What's the third?
Exactly.
The third is
We're moving
to
on.
leave from the courtroom
Whether you
by
like
the
it or
time
not,
the
we're moving on,
right?
dude.
That's the third, right?
And that's what's been done.
Okay. So now, where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal. You
This
can
is
raise
why I
that
say that.
issue on appeal if you are
This is why I say
convicted.
that. This is why I say that though. Because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I wonder if
I
at this
understand
point
that,
she
sir.
even gives a fuck if he
I'm
appeals.
fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law.
Because you don't know anything about the
I
law.
will ask you again. Would you like to come back into this courtroom?
Are you gonna kick me out? Are you gonna kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you gonna kick me out? Are you gonna kick me
Sir,
out?
it's a yes or no question.
Wow.
like to come
I
back
can't even
into
believe
this-
she's even giving him the option
Answer was
anymore.
Based on the reason why I'm answering like that is because the moment I say something, it's gonna get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth.
Now he's
It
projecting.
essentially, it wastes his time, really.
Wastes.
I'm well aware of that, sir, that it delays the
Yeah, but-
proceedings.
Yeah, but then it's laid at my feet as if that's my attempt. You think I want to be over here?
Sir, I don't know what you
Wow.
want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody.
Nobody gives a fuck
Probably
about your
more.
feelings, dude.
And I suggest
still-
that you conform your conduct to the requirements
There
of
is no
courtesy and
conduct.
There you
decorum
go.
so that you don't run the risk of forfeiting your right to be present. But that
All
falls
of
on
this
you
is
and you
wasting
alone,
time.
sir.
All of this
There
is
no
wasting time,
conduct. I don't understand what
and
you mean
he's
by that.
achieving it.
I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine. I can't argue
And
with
you have
about your
demonstrated
opinion.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken.
Those are the
That's the
victims.
word I used during this
Laugh
case.
at life
You
too.
made an opening statement. You
Ironically.
communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand
It's not
English. That's not an
It's
issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision.
Don't worry about it. Laugh at life. It's okay.
To
Your Honor, that's
represent
not fair.
yourself,
Your Honor,
and
that's
that
not fair.
comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
So I'm going to do the
Okay.
following, since I'm not really
Okay.
getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over.
Wow.
And he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer. And after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he
There
will
you
come
go.
back over here. Thank you. We are in recess until that happens.
All right.
I know as soon as I say something, she gonna say, take him out. We're gonna stop.
I'm glad the mic's still on.
And it's just like, well, damn, I could have stayed over there. Like, what the? Yeah, at this point, it's like, what the hell?
I'm just here for security. So if you want to go over there, I'll let them know you're coming back. If you don't, let them know you don't want to go back over.
I'm gonna go over there and get sent right back over here. And then when I get over here, it's gonna be the same thing. Oh well, if you tell them you can come back over here, then I go back over there, then I get kicked out again. Then it's the same thing again. Oh well, if you want to tell, it's just like, dude, pick, man. Like obviously, I don't have no say. That's clear. Because when I'm getting kicked out, the first thing I say,
You're wrenched, Frank.
why are you holding me in contempt?
And Tatted Jedi, your wrench is back too if you promise to behave. And I'm going to ask you 3 times
I don't want to be kicked out.
if you'll behave throughout the duration of this live stream.
Be over here, but why not go back over there?
Oh, they muted him. Boo. Boo. So, I mean, I don't even know what kind of commentary I can add to this at this point. Like, this dude is just doing nothing but like the same thing constantly over and over again. And everybody's talking in circles. Dude, if there was such thing as a super wrench, you would not get one. You would not get one. I'd give Frank one, though. Oh, there was a mic that turned on for like a second. That's what I'm saying, Gray Sky Photo. I mean, that's what I'm saying. Dude, I'm telling you, dude, I hope that she's got somebody at home that is just going to pamper her beyond reason. Like, just absolutely spoil her. Like, her home environment should work the way that stupid movie Wanted is, like, where, like, whenever they would get shot, there's like this weird like wax water that they laid in, and then they just had to sit there for a few hours and then they'd be completely healed. Like she should have that mental wax water bath from Wanted, but the mental version of that when she's home, just to get ready to come back the next day and do this shit all over again. I feel so bad for her. And I wonder if like being in Wisconsin has something to do with that. Everybody in Wisconsin's like super nice. They got that. Anybody you hear with that accent, hers isn't too prominent, but it's there. You know what I mean? Anybody that you hear with that accent, they're just super, super nice. Okay. I've been very patient with you. I've been very patient with you. Oh, that's okay. That's okay. Yeah, good point, Tatted Jedi. Unless Green Bay is losing. Cheeseheads. I mean, you know how humble you have to be to like put a big block of cheese on your head to support a professional team? Oh, shit, I take it back. Yeah, humble would not be the word. Yeah, you just disproved my entire point that I was just making right there, Tatted Jedi. If you're from Wisconsin, nope, everything I said, disregard. Disregard. Yeah, true. Dahmer was from Wisconsin. That also disproves my point. But he was also when he wasn't like killing and eating people and turning them into zombies, he was like super nice to everybody. You know, I mean, but so was Ted Bundy. So was Gacy. So was son of Sam Berkowitz. Yeah, there you go. Polite would be the more accurate. Yeah, polite would definitely be the more accurate word to use. Oh, that already happened. Kaido or Kado? That already happened. Where serial killers were rock stars. They made the Night Stalker, Richard Ramirez, the press just turned him into a rock star. When he was in court, he was wearing sunglasses and, you know, drawing pentagrams on his hand, and like women were sending him like nude pics. And I mean, this was back before the cell phone, before the camera phone, long before that. And like they were writing him letters and sending him like literal pictures, nudes, while he's in jail. It was insane. Yeah, I'm saying it's been happening for a long time. You know, it actually happens less now than it did before. Yeah, Julie Porter. That is a thing, man. Where women just they fall for these horrible people, man. I don't know what it is. And so, yeah, there's an update on the Critical K case. Speaking of women who like to write men in prison, there's an update on the Critical K lawsuit, and she I don't understand it yet. That's why I haven't done a live on it. I would love to have like a civil attorney explain it to me, but I've got the latest court ruling, or at least the motion from the plaintiff. She's not showing up to court at all. Like, she's just basically told the court, no, I'm not going. But it looks like she's going to be ordered to pay if she wasn't already paid. Again, I don't understand the document fully, so this can't be quoted. And I may end this. Hold on a second. I have to check an email here real quick. If I can find my, there we go. Okay, so there's multiple tweets. This is a Quentin Simon update here, guys. Multiple tweets here. Give me 1 second. So we've got an update from Chatham County via Twitter, and thank you for that, Cherry. I appreciate it. And I've just got to bring it up. Give me a second here, guys. But we do have a Chatham County police update on Quentin Simon. So this is news to me. All right. So Chatham County Police Department, the CCPD and FBI landfill search teams looking for Quentin Simon have sorted through literally tons of garbage over the last 4 days. This is a grueling part of our investigation that can only be performed by a team of specially trained law enforcement searchers. Yes. We have worked every day since we got the call that little Quentin was missing. We want you to know how much we appreciate the hundreds of messages of support that our department has received since the case began and how much it means to everyone working tirelessly on this case. The Quentin Simon investigative case team will spend Saturday and Sunday conducting numerous interviews and will continue to analyze evidence they have already gathered in this case. This stand down coincides with the normal hours of operation for waste management and will give everyone a chance to reset before the landfill search resumes just after sunrise on Monday morning. Okay, so basically, for those of you who didn't catch that and understand what that means, they are going to give the search in the landfill a rest over the weekend, but they're going to continue their investigation via interviews and collecting and searching for other evidence in the case. And Monday morning, they're going to resume. Anybody who trashes law enforcement for this, you're an asshole. Because, and I'll explain it very clearly, okay? Only professionals can conduct this search. And there is only so many professionals in that area that can conduct that search. So pulling back, I'm sure they're going to preserve the area for those 2 days. They're going to preserve that area, I'm sure. And these people, they're human. These men and women, they're human. They need a break. They need a break. And I do not blame that decision. I do not blame anybody on the higher ups that made that decision in the slightest bit for letting these professional men and women take a breather from digging through garbage tirelessly from sunrise to sundown for 4 days. Okay. So anybody who questions this decision, you need to reevaluate. And if you jump to a conclusion that law enforcement is not doing their job, you're a moron in my eyes. Sorry, you just are. Things have to be executed a certain way. We have to trust that these professionals know what they're doing. And they're going to do what's best to get a conviction against the suspect that they have, and they're not going to just rush this process because they want to ensure that whoever is responsible for the murder of Quentin Simon ends up in prison, at least for the rest of their lives. And I believe Georgia does have the death penalty. So I'm sure they're going to be seeking that. All right, give me 1 second. Let's get back to this Darrell Brooks thing. All right, and we're back from the recess.
Let's go with Deanna Aldridge.
Exactly,
Deanna
Bees
Aldridge?
Knees. Exactly, Bees
All right,
Knees.
very well.
Mask on, mask off, mask on, mask off, mask off. What in the hell, dude? Oh, I'll be going over all that stuff, Catherine. Don't worry. Not in this stream. I'll do another stream, especially just for those morons. I promise. Now, has he called this witness yet or what? Panda, I just took you.
I'm sorry.
I don't know what
she
you
was in the
want.
other building, so.
It's all right. Thank you for letting us know.
And yes, I know it's cold down here. No, it's not going to be fun. It's going to make me mad. I want Quentin to get justice. I what we don't need and what law enforcement doesn't needs, what law enforcement does not need is for these idiots to go down there interfering with their investigation in any way, shape, or form. What do you want, baby? I don't know what to tell you. I just took you. I just took you. All right. I'll be right back, guys.
Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Come up and have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Okay. Deanna Aldrich, Deanna. Last name is Aldrich.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldrich. Direct your attention. Well, first of all, let me back up a little bit. What do you currently do for a living?
I'm retired.
That's always pretty good.
You're retired too, dude.
Direct your attention to the evening of November 21 of 2021. Do you recall
The victims.
Pretty good.
Those are the names on the screen.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV.
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
description
what?
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was. And they were gonna walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah.
Do you recall how many people there were?
Maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And
He's acting a
you know
whole
if
lot
they-
better these moments in this trial now.
Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
They probably had body cam. That poor lady's so nervous. You see her? She does not like being questioned by him. Oh, that poor lady. She's shaking. She's literally shaking at having to sit there and look at this guy. And it's his witness.
If you recall, did you ever learn what the loud noises were that you heard?
Oh, that poor
before
lady,
you
man.
seen
I
the
feel so bad for her.
SUV?
No.
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, what street did you say?
Arlington.
Arlington. I apologize.
Fuck this guy, dude. Catherine 662. I'm debating it myself. I'm debating it myself. I'm thinking about busting out the Jameson.
Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
If he asks why not, I'm gonna shit a Miata. There's not, Roxanne Polk. This is all a tactic to delay the inevitable
After you
on his part.
spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came.
Oh, he already tried, Roxanne.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Well, Shelley's beauty addiction, he's saying he because he's pleading innocent. So he's trying to lay the foundation that it wasn't him that she saw. And she's looking right at him. And you see how angry she is for having to be in this position. And you see everyone empathizing with her I mean, this is an absolute farce.
Do you recall the name of the officer that interviewed you?
No.
I feel so bad for her.
No further questions at this time.
Look at you.
No cross, Your Honor. Thank you.
Yep, let the lady go home. That's it. Let the lady go home. Let her put this all behind her.
Defense may call the next witness.
Just call the fucking witness, man. Come on. Let's go. Move it along. Let's go.
Just 1 second, Your Honor.
Oh my God, bro. Totally Lex. That lady, the poor lady was just shaking from anger.
Defense calls Christopher Bertram.
All right, thank you. I presume the state heard that.
Yes, Dawn, I agree.
Your Honor, my assistant.
I didn't want to assume. So thank you for
Yes.
verifying that.
Like anybody who even wasn't at the parade but had to talk to the cops,
All right, good.
had to
Asking
see
Mr. Bertram
anything
to
relating to that
stand,
event,
which is
like
off to
they're
my right, it is
victims.
up
To a
one
certain
riser.
degree, they're
When you
victims.
get there, please remain standing, raise your right hand. And my clerk Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Have a seat, please. First thing I will ask you to do is to state your first and last names for the record.
My first name is Christopher and my last name is Bertram.
Could you spell those, please?
CHRISTOPHER BERTRAM.
Thank you. As long as you sit close to the table, you will not have to lean in. Go ahead, sir, your witness.
Oh, I'm sorry.
Go ahead, your witness.
Now he's acting like a choir boy. Unreal. Wow.
First of all, good afternoon. What do you currently do for a living?
I do electrical work.
Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our mechanic friend.
Were you aware of a parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
And at the time you observed this smashed up car, as you say, did you see anyone driving it?
Yes.
And were you able to make a description of who was driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
You made reference to giving a statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
Did you observe the vehicle stop at any point in time?
No.
So it's pretty much you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tents?
Any what?
Tents, like tinted windows?
No.
See, the way that he's behaving now and his line of questioning, it's clear to me now that everything before was exactly what we thought it was, which was a tactic to stall, just to throw irrelevant shit out there, cause objections, argue with the judge over the rulings of the objections, just to stall.
Was your interview with law enforcement the same evening that you saw this vehicle or sometime after?
The same evening.
Do you recall stating during the interview that evening that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall stating at any time during
See, this is a good move on his part because he had long hair at the time.
You saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
So if he did say that,
did you ever see them? Did you ever see what you believe?
Ultra Dark CEO, I think
No.
he's very uneducated, but I think that he is aware of his manipulation tactics, and he's been
I was unsure.
achieving his goal with his manipulation tactics up until this point today.
Do you recall in your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
Well, thanks for joining me, Sherry. Yeah, I really appreciate you guys being here and watching this with me, hanging out.
And where did you
hit that
where
like
did
for me if you
observe
can?
The vehicle go after it had passed you.
I turned away after it passed me.
I wouldn't call him a master
Do you recall
narcissist.
what the
I
operator
think he
of
has
the
narcissistic.
vehicle was wearing at the
I mean, I'm
time
not
that
a
it passed you?
doctor, but
do not
he
remember.
clearly has narcissistic traits,
Do you
characteristics.
recall during your interview with law enforcement that evening
But to call him a
stating
master
that
narcissist, I think
you
that's a
thought the operator
stretch.
was wearing a black sweater or jacket as it drove past you?
If that is what is written,
Do you recall seeing it?
no.
Thanks, Heather
And do
Bishop.
you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
Yeah, same, Catherine. That's exactly why I went live. Really, like I don't
was
have any.
anyone present with you during
I don't
your
have any
interview with law
expertise in
enforcement
this
that
area
evening?
in the
Yes.
slightest bit
And
to
who's that?
add,
My mother.
insight. But yeah, I'd rather like not feel like a total nutcase yelling at my phone while I'm
And
watching
do you
this
recall what
or
agency
yelling at the screen.
your interview was conducted by?
Yes.
And would you state for the jury in the record?
The FBI.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do you recall
The air quotes. I love it.
I think that's a little bit unfair to say.
Great.
If you had to
Great
estimate
lawyering, thinking out loud as you deliver your line of questioning. That's
where
good.
where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
Do you recall seeing the vehicle that you observed crash into anything?
No.
I mean, on the one hand, he's calling the right witnesses because this guy really didn't see anything, according to his testimony, according to everything else. He just, I mean,
Do
but
you recall
it's
stating in your
it's a moot
interview with
point.
law
It's a waste of
enforcement that evening
time
that the vehicle appeared to slow
because there
down
are plenty of eyewitnesses that
traveling
saw him
down
do what he
Prospect
did, and he's
Court?
on video
Yes.
and camera doing it. So this is all just a big waste of everyone's time.
At some time after observing this vehicle, did you call 911?
Yes.
Do you recall around what time you called 911?
No.
Do you recall shortly after seeing this vehicle texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
This kid's like, I'm not giving you shit, dude.
see anyone else in the vehicle?
No.
You see how he was so specific on that? Nope. Only one person in the vehicle.
Seeing the operator
No
in a black
accomplices.
sweater?
Just your
Don't
dumbass.
remember.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds.
This answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross? No. Thank you, sir.
Nope.
You may sit
Let him
down.
go back to his electric job. Good on you, kid. Good job. Fuck are you smiling
Call your
about?
next witness.
And when we get to the next break, I have something to discuss outside of the presence of the jury that pleases the court.
Do you want to do that now or after your next
We
witness?
can.
All right, I'll address a legal issue and we'll bring the jury back in when we're ready. I'll rise for the jury, please. Everyone can have a seat and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
I'm curious.
Here we go. Oh
Some
my
of these,
God.
Judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis.
If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then that's,
about that.
all right, then I'm going to bring the jury back out. You're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this
So
time.
what is he
If
trying
you
to
wanted
say,
raise
that
a legal issue,
that the
what's the legal
prosecution
issue?
tampered with his
The
witnesses?
legal issue is
I missed it. I was answering a
how is
text.
the state allowed to coach the
You're
people
assuming
getting
they
sending
spoke
one,
to them and coached
rather.
them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a
All of
foundation
a sudden the
with
state
these
don't got
witnesses.
all of a sudden for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try.
What if we could see cyber threats in real life? Yesterday's
Oh my God.
technology can no longer stop them, but
Skip
they can be.
ad.
To try to get through the case. Hurry up. We just gonna let these people go.
Well, this
And
is
not-
argument.
Come on, man.
This is argument on your
I
part,
see
sir. It
through
is
it.
pure
I just
commentary at
want
this
that on the
point.
record. I see through it.
What?
And your
Nice
see
try,
through
but I see through it.
has absolutely no basis in
But
fact.
I know that's what's being done.
You could
They don't
ask these
need
you could
Come on,
ask
man.
these
to
witnesses
cross-examine,
certain
dude.
questions, and you're
far,
not.
far from the idiot.
They're your witnesses, sir. You believe.
So
Are you though?
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
Well, you can't
I
ask
find-
that, but
I
you can
find it
ask them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's no
recall seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought out.
Shannon, 'cause I wear
instructing you
shirts that
to
show off my
avoid the
sexy
commentary
body.
When the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
Pick up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to run the
disagree.
record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me.
witness
So let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I
Wow.
leave the table, I'm away from the courtroom.
This
and I have to
dude, man,
elevate my voice.
he
This is the
So she had
alleged
the elevator
record
voice
of Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept the value in return for value.
you were doing so good through
One more
those two
interruption and
witnesses,
you're gonna be
bro.
removed to the next
Like,
one.
what are
That's
you
what you do
doing?
anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003. Criminal
Ooh,
trespass
he's mad.
dwelling from
All
2006.
right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
This dude is unreal, bro. Hold on. I want that paused on there, bro.
Me, it's very
Dude, like, you can't even, everybody keeps talking about there being a Netflix documentary on this and you know how there's going to be a movie. Dude, that would be a boring movie, dude. Like, just like, if it wasn't so disrespectful to the victims, I could see a spoof movie being made, like a comedy. But there's no way. Like, I mean, there's nothing. I I don't see there being a movie made that's going to take 2 hours to make the point that this guy just held up court and just continued to victimize victims. Like I don't see, and they'll never make that spoof movie because, like I said, it's too disrespectful to the victims. The idea of it makes me mad. I mean, I can't now. It's like I can't end this live yet because I have to see what happens next. I can't. I cannot take my eyes off of this train wreck. This is insane to me. Like at this point, like since he can't argue, since he can't be argumentative because she's going to put him in another room and mute him, since he can't do that, now what he's chosen to do is intimidate the judge with threatening stares. Unbelievable. Like I've never seen anything like this. I mean, when she said in her career, because there's no doubt in my mind that in her entire career, she's never had to deal with the defendant or deal with a case, a trial this difficult. I totally get that. I have no doubt in my mind that's true, but I would venture to say that probably in that entire state's history, there's never been a trial this much of a farce. I would imagine that. I know that in my lifetime, there has never been a high profile case like this, a high profile trial like this. There has never, ever been that in my lifetime. And I've been on this planet just a few years shy of a half a century. Like, this is crazy. And he got the judge to the point to where she's like, I have to take a break. I have to take a break because he's making me uncomfortable. He's scaring me right now. I've never seen that happen. I've never seen a judge do that. I've never even heard of a judge doing that. This is insane, bro. Oh, yeah, dude. The memes, Beastly B Hernandez, the memes from that still are coming, bro. The memes from that stare are gonna happen. I guarantee that. Yeah, his manipulation's just not gonna, it's not gonna fly. It's just not gonna fly. I want to make sure that I've got this like playing. Oh no, I still have it paused. Okay, there we go. Well, reluctant healer, that's the problem. If she charges him with contempt of court, he can appeal. She's trying to avoid all the appeals. This is why I'm saying he's not as dumb as people are thinking. Like, he's coming off as dumb in a lot of different ways. Sure, he's dumb in certain things. Like, he's dumb when it comes to even vocabulary. But the fact of the matter is that he's also, he knows that he can manipulate a mistrial and he can manipulate contempt of court in order to be put in a position to where he can appeal. And she's simply trying to avoid that. Like, people have been put in contempt of court for a lot less than what this dude has done. Yeah, Johnny Cuddy, I agree. I think she's absolutely had it, man. I think she's and I feel so bad for her because I bet you anything she wants to quit. She wants to recuse herself from the case, have a new judge assigned. I feel like that's what she wants to do just for her own sanity. And I feel really bad for her because if she does that, that's going to be a mark on her career. You know, she's going to be known as the judge that let the defendant beat her in court. She's going to have that, you know. I mean, her chances of starting a private practice and it being successful, her chances of running for political office if she chooses to in the future, I mean, that's just going to be really bad. Wow. Thank you again for that Cash App. I don't want to say your name, but thank you so much for that Cash App that just came through. This is the craziest thing I've ever seen. I mean, she is a victim of his abuse right now. This judge right now is a prime example that this man is abusive towards women. He is a shining example in every which way of how a man can be abusive towards a woman without ever having to lay his hands on her. Or even cuss at her, you know, or even directly insult her. It's insane because she is wow. I feel so bad for her. Like, she's probably going to need therapy after this trial, depending on how long it lasts. Like, she's going to need therapy to recover from this. This is traumatizing. I mean, is it not? I mean, if you think about if this trial goes on at the pace that it's going, think about how long it's going to take. Think about how much she's going to have to hold in her emotions and behave in a professional manner, and for how long she's going to have to do that and put up with this. Any person, not just a woman, any person in this position would have to seek therapy after this. They would have to, like, I mean, this would traumatize anyone. This would traumatize anyone because this is an ongoing thing. Oh, yeah. Yeah. The jury's going to come to their decision like this. Like, do we even need? The foreman of the jury is going to be like, people, do we even need to have a discussion here? Let's just raise your hands. Like, and I can't wait. Oh, I can't wait till the judge passes down that sentencing. Like, that's going to be her day, bro. That's going to be her day. The day that she gets to pass down that sentencing, man, that's going to be her redemption. Y'all see, like, there's movies like, and I get it. People get triggered. I get triggered real bad. Like when I watch a movie where there's an SA scene, right? I get triggered real bad. I have a hard time with that. But a good movie that has these scenes in them and they're graphic, they will counter that scene with a graphic revenge scene that makes up for it all. It just makes up for it as the viewer. For the viewer, it makes up for it for the viewer. For someone who's sitting there and just going, Jesus, you know, like every time there's a movie with a scene like that in it, I'm turning my head like this and I'm just like, come on, you know, like this has got to stop. Like, how long does this have to be? But then there's always a redemption, you know, like the girl with the dragon tattoo. That revenge scene was dope. Was amazing. It was so good. And that's going to be the day of sentencing, in theory, is going to be, for me, that redemption as the viewer. You know what I mean? Oh, looks like, well, I don't know if they're coming back in or what, but there's some dude's bald head. I don't know if I've seen that. Let me see something real quick. Oh, yeah, man. Yeah, but I thought that movie fucking sucked. That Luckiest Girl movie. Like, it was a good premise, but it wasn't very, like, well executed. I just didn't like the movie. You see how quickly I forgot about it? You're like, Luckiest Girl. And I'm just like, man, that sounds familiar. But I found it to be extremely forgettable. Sorry if you disagree with me, but yeah. But I'm pretty critical when it comes to movies. Well, right. McCarmel, last time I went live about this, Bundy, that's common knowledge that Bundy had defended himself in court. But the difference was Bundy went to law school. Bundy knew the law to a certain extent. And the judge even like gave him props. At the end of the trial, the judge even like congratulated him for, you know, presenting a decent case for himself. But he also wasn't having it. You know, like I wasn't about to like, but yeah, Bundy was like almost a lawyer. But this dude, he's just a thug. He's a woman beating thug is all he is. Well, Kaido, yeah, he re-traumatized people because I mean he had to call witnesses and you know, people that I mean I don't know the details of his trial, but I would imagine that I mean there were survivors, and I would imagine that they would have had to testify, and I would imagine or I would assume that they were definitely re-traumatized after the fact. Yeah, Heather Bishop. Yeah, his vocabulary is really annoying because he's not even learning as he goes. You know what I'm saying? Like if the judge and the prosecution are constantly saying the word relevance, they keep saying relevance, and he keeps saying relevancy. you'd think that he would correct himself at some point and just be like, oh, okay, well, I guess all of the educated people in the room are saying relevance, and that's actually how you use that word. So, okay, I'm going to start using it that way. I mean, but this is the epitome of ignorance, is this guy. Yeah, that's right. One of the witnesses had escaped him, right? I assume that he had to question her on the stand at some point. Bundy, I'm talking about. Crispy critters, you're not blocked. I can see you. Everyone can see you. Or crispy treat, I don't know. I don't have any idea. But this one I see. But I'll let you guys know. Once I hide somebody in this chat, in this channel, or once Cherry hides somebody on this channel, that is permanent. Like, I am not going through the tedious task of going through my hidden list to find somebody and unhide them. So chances are you did something to get hidden. But you are free to create a new Google account and conduct yourself accordingly in my chat after the fact. Like right now, this is crazy. Like right now, they're on a break because the judge has to collect herself. The judge has to like woo-saw and do whatever she's doing to collect herself, probably on the phone with somebody above her and saying, what can I do at this point? I can't keep doing this. I don't have much more in me to keep doing and dealing with this person. I've tried everything to be fair to him. I've been beyond fair to him, and yet all it's doing is making the situation worse. Cellar door, yeah. I mean, I think what she's doing is trying to find an option here, because she is in a very, very, very bad position. She's in a very ugly position that I would wish on nobody. Because if she quits, it's going to be extremely damaging to her career, because this is such a high profile case and victims' families are counting on her right now. It would just be really, really bad. So, you know, I'm sure she's trying to figure out her options, because make no mistake, right now in that courtroom, because of the pressure that she's under, that's being used to abuse her by the defendant. It's being used as a weapon to abuse her by the defendant, by Mr. Brooks. Yeah, her Rocky moment's going to be the sentencing. Like, that's what I would be doing. Like, if I was somebody in her life that she would call up and be like, I just need to calm down. I don't know what to do. I'm going to be like, just think about that sentencing. That's going to be your moment. Just focus on the sentencing, because there's no fucking way, unless you let him, is he going to get away with this. Focus on the sentencing. Relax, breathe, focus on the sentencing. If I was somebody personal in her life, that is exactly what I would be coaching her to do. That's how I would coach her through this. Yeah. So, okay. So people are saying that there's only a couple of witnesses left. So if there's only, I think somebody mentioned that there's, I think 5 witnesses left, that they think there's only 5 witnesses left. So we'll just have to see. But hopefully, I mean, I can't put a time frame on how long that's going to take, but I know that everyone in that courtroom, except for him, wants this to move along. So that's why the judge is going, call your next witness. I don't want to hear it. Call your next witness. And he's really angry right now because she's got him railroaded, in the sense, not legally railroaded, that's wrong, but she's got him put in a position to where he just has to move forward. That's it. No more of this, no more of that. Just move along. Yeah, this is just crazy, dude. I don't even know, man. I've never seen anything like this. Yeah, I don't see how, like, unless she's a saint of some sort and is trying to get her own ticket into heaven, I don't see how he's not going to get the maximum penalty here. And whatever that maximum penalty is, I don't know what it is in the state of Wisconsin. Larry 5200, yeah, but, and I'll repeat, I had an attorney who's also a creator in the chat the other day when we were discussing this case, and I was actually agreeing with your statement, like, loudly. I was just like, man, she's just let him have control of the courtroom. He's taken over this trial and control of her court. And she needs to take that control back. And just put her foot down. And I was saying things like, oh, she just, that's it. Like, just put him in contempt, do God knows what, whatever. But then that lawyer explained to me that there's a reason why she's giving him all the leeway, is because she does not want him, once the conviction is made, she does not want him filing for an appeal. She doesn't want to leave any room for appeals to come. So that made perfect sense to me. But I agree with you. It's very, very frustrating to watch. And why does he have a mask on now? Like, what? Mask on, mask off. It's weird. Right. I'm not a mental health professional, but this dude is definitely exuding all of the characteristics of anyone that I've ever seen that has been diagnosed with oppositional defiant disorder. Absolutely, Onyx Angel. Right. Reluctant healer. I agree with you. I think that's going to be what he's going to try to pull. We'll see. I mean, he's going to try to appeal, but they're all going to get shut down. I guarantee. Like, this is going down in history. And there's no judge that's going to grant any appeal from this guy. I don't think.
Or
I mean,
before-
I'm not a lawyer. I don't know, but I just can't imagine it. In theory, I can't
I'd
imagine
like
it.
to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness. I trust that you're ready to do that, sir.
I hope she ate an edible.
All right, then.
We
Madam-
need to complete the task of. the
Oh, we do.
priors for Mr.
I knew I would left something in my office, but I reviewed it, so go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously that would not have been a crime, but everything from OWI second on down, we believe would be appropriate. There's also one that's noted, 06 CM 2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk.
I'm wondering what the significance of that is right now, though.
Remind me the statute again on priors.
90609.
Thank you.
Yeah, like what's with the priors? So 7 priors. So this guy's got a record.
And a copy of
Not
the
as long
record
as
provided
Betty's.
To the defendant.
Not even nearly
It
as long
was.
as Betty's.
It has not been discussed with Mr. Lozano.
But he has a record.
That was going to be kind of my next topic once. Thank you. I look at this again. All right, Mr. Brooks, do you have a position on?
Well, that was
the prior
explained,
convictions
Joe
for this
Nathan.
witness?
That's kind of a stretch to call him a chomo necessarily. But he is a sex offender with a record. He basically what happened was the woman that he impregnated and had had kids with, she was underage at the time, and he was charged with statutory, not statutory R, but statutory something else. I can't remember what it was called, but to call him a chomo, it's a touch much.
The state is asking for a determination
Murderer,
by this court
liar,
that there are 7 prior convictions
domestic
for
abuser,
purposes of
all valid.
questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
What? I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior convictions.
Yeah, I want to know what's up with that. Thank you, Cherry.
I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't.
No, there was one state's witness that had one prior that we discussed. And
That's
the court
right.
ruled.
We did. I recall now. So at that point, I directed your attention to 90609. And then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of questioning of
I
this
think
witness.
he
Do you
failed
have
to even
any
register
comment,
himself. He
statement,
was
or
supposed to
position?
register himself, and he failed to, or something like that. Okay, Onyx Angel, thank you. I think that's what they said. Yeah.
Looks like it's 9 on here.
Which is the one the state referenced?
Joe Nathan, yeah, you're
that
right.
The charges are listed, but they were dismissed.
2000, well, it's recorded as 06 CM 2039, 2 times violate.
No.
restraining order.
Common
This says
sense, he's not
EM/RI,
mentally ill at all.
Which means dismissed and read in.
That's
2
like
X's,
saying that Dahmer should have been
MPJ,
deemed
which would be
mentally
2
ill.
times, misdemeanor bail jumping, dismissed and read in. So no convictions from that file.
So why is it on the sheet?
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
And he was evaluated more than once, by the way, Common Sense. And he was deemed fit to stand trial
Nothing
and defend
since
himself. So they
2007.
can't appeal that.
That's correct.
That ship has sailed.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
What is dismissed and read in? Does that mean there was no charge?
No, it means it was when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why my understanding why it was listed.
Yeah, the Watcher was great up until the end.
So where it says dismissed and read in, that would be the restraining order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8. Should be 8.
The Carmel, I don't know, but it's on Netflix.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI?
Adria Martin,
OWI
Morbid's
first would
on
not be a
vacation
crime,
right
it would
now.
be a forfeiture.
But we plan on putting something together soon. And I'm sure he'll go live on his own channel when he's back from vacation, but he's currently on vacation right now. People are getting mad that I've been collabing with Morbid. People are getting mad. Don't they know that that's just going to make us want to do it that much more?
All the way up to a 5th.
What are you going to go see, Shelley's Beauty Addiction?
Remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case, convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Less than what, 8?
Well, it'll be less than 7. He has 7 convictions as I count them.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7. Should be 7.
All right. Do you want to make any argument? about
Terrifier
whether any should be
2.
excluded under the statute based upon the factors I just read to you?
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole.
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
She's doing his defense for him. Like, basically, the prosecution's trying to discredit his next witness.
But if it's 7 on here, well, I guess it brings it to 7. And
Dude, what does it matter?
whether OWI first is not a crime, it still counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first. Looks like 7 to me.
All right, then. Anything further from the state on this? Given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions.
I don't understand. Are they talking about a witness or are they talking about Brooks in a third person?
Other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
Yeah, it sounds like it's a witness.
We'll have to be told to Mr. Lozano before he testifies, Your Honor, I believe.
I agree. State willing to relay that information?
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr. Lozano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
For sure, Mr. Hayes and Mr. Lozano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
All right, so Hayes and Lozano are still here.
Yes.
All right. Those are the 2 who are here, sir. I'll tell you what, either way, let's just bring Mr. Lozano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please. Can I have a first name for this witness, please?
It's
Abel,
Abel,
thank you.
but I believe it's pronounced.
I love how he's the frustrated
A-B-E-L.
one here. He's sitting there, oh, like he's the frustrated one.
Abel, thank you.
Abel.
Subject matter jurisdiction, Your Honor.
Court declines to address that.
Yeah, that's what I'm gathering, that it's a witness. I just wasn't sure. I didn't understand.
For the record. Do you want Mr. Lascano on the stand, or are you going to call Mr. Hayes first? Just so I know what to do when he comes in.
I don't currently I can't find paperwork from Mr. Hayes. Can a police report or something be provided in case I want to call Mr. Hayes first?
Yes, we will
Right.
accommodate that request. It'll just take me a minute, Your Honor. to find
Reluctant
it.
healer, I agree with you. I think
I'll
that
have to have it printed and brought
I think that
over.
he is a career underachiever, a lifelong
I
underachiever.
will give you permission to
And
email it to
he-
Teresa, and she can print it in the courtroom.
Well,
That will assist.
It's part of a 700-page.
The only
PDF, so I
thing
can't
keeping him
just,
from breaking
email one
here
page.
is his instinct for
I
survival
don't know how to
because
do
he
that.
knows his life is over.
Copy and paste it into a Word document. I'm ready.
That's all right. You can do it the way that you need to. Great. Mr. Lascano, I'm just going to have you for a moment take a seat. You're not going to testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to have you come up to the witness stand. I want to, everyone can have a seat. I want to advise you that I'm aware you have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks a follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
You understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then. Thank you. All right, then let's have the jury brought out, please.
Oh, I remember that. I remember hearing one of his raps at one point when this happened, when this tragedy took place. And doesn't he suck? Isn't he like a bad rapper?
All right.
Yeah, that bailiff, man. I feel so bad for that dude. Like, I bet you he's wanted to go behind him and put him in a chokehold like at least a dozen times this whole fucking trial, dude.
Thank you, everyone. Please be seated. The defense may call its next witness.
Kaido, to answer your question, I'd say stupidity is what does it. Stupidity is what pushes an idiot to commit such craziness.
Defense calls, is it Jason Hayes? Jason?
All right. We'll have the witness brought in. Is it Haynes or Hayes? Does anyone know?
No end for the best of my knowledge.
Hayes? All right. Good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa.
Okay, so this is not the one with the record,
Do you solemnly
folks.
swear that the testimony you're about to
I mean, he might have a record. I don't know.
about the truth
but-
self you got?
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir, your witness.
Fox 9 needs to mic him. They don't have the witness stand mic'd right now.
I accept for value and return for value this document for the record. Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
There they goes.
Been doing that for a long time?
21 years.
His attempt to be professional all of a sudden just kills me. It's just so funny.
The evening of
yeah, a long time.
November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
It's got to be so surreal for these witnesses, man. What a surreal experience this must be for them.
What were you doing that evening?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before
Welcome,
the
Lilith
parade
Kane.
started.
Were you scheduled to do any marching in the parade itself, or
No.
just spectating?
Yes.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah, yeah.
I just wanted to make sure there was.
He answered. He answered.
Oh my God, dude.
Anything unusual catch your eye?
Like,
that
I've
day?
never
Did you
seen
recall?
anybody so combative as this guy.
Yes.
And what did you see?
He doesn't have a defense, Catherine
Besides the
662.
parade?
It's all a tactic to stall
That
the
that was
inevitable,
unusual. That caught your eye. That
or to get a mistrial,
Where
or
we
an,
were,
you
yes,
know,
a red truck came
an
through
appeal.
where we were. It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that?
We were all the way at the beginning of the parade.
Okay.
Like it was Main and corner of Main and White Rock.
Okay. And you said you observed this vehicle honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
That's a leading question.
Where?
Or was it? I guess the correct question would be, why did it swerve?
There you go.
I don't know. I wasn't driving. I don't know what it is.
The prosecution didn't even object. Like, that was clearly a leading question. Could have been swerving towards something, could have been swerving away from something, could have just been generally swerving.
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
So well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight.
You see,
down
he's
Main.
trying to discredit these witnesses by being
Like
like,
saying,
they're going to be like, I don't recall what I said, you know?
Did you
And even if he discredits them, it
get a
won't
description
matter
of who
because
was
there's
driving the
video
vehicle you saw?
I
proof,
did not.
indisputable proof.
Did you get a
The
license?
witnesses
plate?
don't matter.
Did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you were, or you
either were interviewed by law enforcement or seek to be interviewed by law enforcement?
I don't know, McCarmel. That's actually a good question. I don't know if he was under the influence of anything at the time necessarily. I mean, he
And
might
do
have
you
been,
recall
and
if that
I
was
just
the
don't know
same
that
evening
detail, but
or-
somebody in
It
chat
was
might
not the
know.
same evening.
So
It was a
that
couple
day
days
I
after.
don't know. Oh, that's pretty. Shut up.
Do you recall in that interview that you had with the detective
I don't know, Catherine.
stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes,
So in your opinion, it wasn't trying to strike the kids?
correct, yes.
And after it continued, I think you said east.
Yep.
Would that be correct? East?
Yep.
Did you see the vehicle strike anyone? When
I did not, no.
Do you recall what side of the street the vehicle was traveling on at that
It
time?
was on the right side.
The right side.
So we were on the north side of the road.
So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes,
So you never saw it go to the other side of the road or?
no.
No further questions at this time.
Thank you. Any cross?
Yes, just briefly.
Mhm.
Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Yeah, it's not their witness,
And
so
do you remember also telling the same
she
officer
can
that the
form the
SUV,
questions in any way she wants,
took
pretty
off
much.
down the street and that it accelerated?
Yes,
Objection.
Is that
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled.
How's he gonna know?
Statement, continue asking the question.
I guess I was asking was that referring to the interview officer?
Your
Oh my
objection is
god,
noted. It's
bro.
overruled. The statement asked the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
yes,
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
yes,
Is that accurate with your recollection of the driver?
yes,
But you didn't see a face, you couldn't
no,
identify anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
no.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirects, sir?
Briefly.
Oh my god, dude.
Very briefly. You made a reference to the driver of the vehicle having a dark complexion. What would you consider a dark complexion?
Do I have a color graph that I can reference?
Reflection, I don't know.
I mean,
It
I'll
is
point to the
dark.
one that was closest to what I saw.
Did you notice any clothing?
I did
on
not
the driver?
know.
Like
did you
not
notice any hair?
consistent with Caucasian, maybe.
No further questions.
All right, thank you. You may step down. And you are excused. The defense may call its next witness, please.
Oh my God. Come on. Another one down. Let's go. Let's go.
Arriving at 3:30. Just saw it.
I'm not sure.
Badiats and Darrell will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
I knew who's here now. Just trying to get clarity.
Are you going to call Mr. Liscano?
Just fucking call Liscano, dude.
Hey, would
Just
appear
call
so.
him.
He's the one that's here.
All right, then he may, the defense is calling Abel Liscano.
Wow.
Correct?
The defense is calling Abel.
Oh no, he has no remorse at all. He clearly has no remorse. It's all about him. Like even in the interrogation, he was like, all I keep thinking about is that my life is over. My life is over. My life is over. He didn't ask the well-being of those who were injured. He didn't. Yeah, he has zero remorse. That's already been established just from the officers going over the interrogation on the witness stand.
When you get there, please remain standing, raise your right hand. And my clerk Teresa, who will be across from you or is across from you, will swear you in. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Liscano, ABELLAZCANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Liscano. What do you do for a living currently?
I'm a hairdresser.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Okay, where's this
Do
going?
you recall the night of November 21st, 2021 pretty well? I know it's been a minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or,
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Now keep in mind, this dude, I think his last conviction was 2007.
That part of Main Street close to like a side.
So the benefit of the doubt,
if you recall,
stands as far as him having his life together, having a family, and doing whatever he needs to do. He's got a legit job as a hairdresser. He's doing okay.
Barricaded during the parade.
I don't remember.
Do you recall what time you arrived at the parade that evening?
Yeah, it just started. So whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
Wow.
And
he's not taking his eyes off of him either. This dude is like Like I've done some shit, but I ain't never even thought about doing some shit like that. You're a piece of shit.
Yeah, you're standing right there.
Yeah, you. Panda, you're unplugging my stuff. There you go.
And how many people did you see in the
Okay,
vehicle?
lay down, baby.
Just one, the driver.
So, do you recall
The most
flagging
famous reindeer of
down
all?
a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection. First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
Yeah, this guy's not stupid. He's like, nah. Yeah, I don't remember saying that, dude.
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Is that all you recall about your description?
That's all I remember.
Dude, come on, man. Move it along. Look, let's go.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
Yeah.
And where did you go?
None of
We
your
headed
fucking
back to the
business.
car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or buildings on Maple Street.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
What's funny is
No, I didn't see
like
it stop, no.
Brooks is a wannabe thug. He's
going
just a
through the
coward. And he's looking at a real, like, he's
And
looking at a
speaking with,
real thug. One that's reformed, one that's like,
Detective Moss?
I already did all that shit.
Well, speaking with law enforcement,
And he won't make eye contact with him hardly. Like, he knows, like, Brooks is
Do you recall
intimidated by this
advising
witness. And I'm
law
loving it.
enforcement
All of a
that you
sudden,
observed
he's
3
slouching.
black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show
Like, the tough guy act is
refer
gone
to
right
page
now.
4
I'm
exactly.
loving this.
Is it a statement this witness personally wrote?
I believe it's with. I don't think he wrote it.
That's real,
himself.
true Montour. That's real. Like
But,
a real thug would be like
I don't
lawyer.
know if it's Officer Moss or Detective
Lawyer.
Moss. I'm not sure what his rank is.
Sin miedo.
Continue with your questions. I'm gonna deny the request.
Eso
Show
sí es verdad.
the exhibit or the paperwork to the witness.
And I wouldn't say that. I'd say
Do
most,
you recall making
most if not
statements
all of them
to
have
Detective
not
Moss
been afraid of him. They've just been angry.
that you observed one where it says one was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other two were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as two short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car. Trying to get them to safety. So I was keeping an eye out and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Yeah, Kaido, that doesn't matter here.
Do you recall why that would be reported?
That would be relevant if there was a hate crime charge, and there's not a hate crime charge. So whether or not he had BLM on his Facebook or not is totally irrelevant. It doesn't matter what some people believe. Let's try to keep this to relevant facts if we can.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to where the vehicle was ultimately found?
Yeah.
Do you recall yelling at subjects standing outside of the building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
This is not going to turn into a racial or political thing, people. This is your only warning. I don't care who you are. I don't care if you're a member. I don't care if you're a wrench. We're not turning this into a political or racial thing. That is not the issue here. And we're not going to start that discussion in my chat, and it won't be tolerated.
Do you recall stating that? Well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
Yes.
And do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening.
Yeah.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Makes sense. That's a perfectly reasonable assertion there.
The question actually was in reference to when you spoke with Detective Coates that evening, in reference to seeing the vehicle in the parade as it passed you. Do you recall at that?
Oh yeah, I agree with you.
While at the parade, that
Dorinda with a big R.
Do you recall stating to Detective Coates?
I'd say that
appeared
that he has a very
intimidating
presence
during the parade.
Because I think that Brooks is actually intimidated by him.
Any reason why the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Do you recall in your interview with Detective Coates that evening stating that the three individuals, and I'm referring to who you saw next to the vehicle, so clarification. The three individuals who were standing in a line, shoulder to shoulder, as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
I saw at least two of them. And look like they were standing in front of it.
Like, how many times does he have to go over that? He saw three males standing next to the car, while everyone else was running. So that stood out to him. And this is what he reported to the officers. And he described them as best as he could. I mean, that would have stood out to me too. Everybody else is running, but these people aren't. Like, I don't know if I'd go as far as to call it suspicious, but it's definitely something to question.
Do you recall stating to Detective Coates that
Roxanne Polk, thank you so
may be
much.
able
I
to
appreciate you.
recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
I don't remember.
Oh my God, dude. There's no point to any of this. But I wonder where he's going. Like, I'm wondering if he says, since he described them as being three black males, I think he's trying to create that doubt, which is a smart move, but it's not going to fly considering all the evidence that's already against him. But he's trying to say that it could have been any one of them, right? If all three of these black males were standing there, it could have been one of them.
Any reason why
that was driving the car?
I'm not gonna say
not me.
Two. Any reason why the two detectives that you spoke with that
but
night,
it's not going to fly. Like, it's not going to hold any water.
That you stated you saw three black subjects running from the vehicle?
No.
And during the parade incident, were you or anyone you were with injured that evening?
No.
He already asked that.
No further questions at this time.
Thank you. Any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
Good afternoon.
Here we go. Objection.
Sir,
Objection. Grounds.
You said you watched the parade near Curry Insurance. Is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade? Yes. Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overrule. It's cross.
No,
Speculative. Objection.
Overrule. The witness may answer.
There.
He says no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
Overrule.
About how many people did you see the SUV strike, sir?
This fool, dude.
Overrule.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in there.
You remember that?
Yeah. It was right in front of us.
Yeah, like the car key was was on him.
Right hand in the air, directioning his hand from right to left. describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Thank you. So, Mr. Lescano.
Yeah,
I wanna
it's
talk
a
about the
slam
moment when
dunk,
you located this
Sherry.
vehicle on Maple,
It's a
okay?
slam dunk,
I'm
but
gonna ask,
it's-
Madam Clerk, could you please turn on the AV system? We're gonna put up State's Exhibit 65.
Go ahead.
Objection to the relevancy of Exhibit 65.
it's relevance, man. How many times have you heard anybody
Noted,
say the word
overruled.
relevancy except
Been
you?
received.
You're the
statement
only
is received.
person.
All right, this total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection
Okay.
speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
Overruled. You may answer.
Yes.
That looks right, correct, sir?
Objection leading.
Overruled.
All right.
Dude.
We're gonna, clear the screen.
She can ask leading questions. It's
and we're gonna play
cross,
this
you
entire
idiot.
clip For 36
Shut up.
seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor? Is that attacking agreement?
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
That's
No,
not speculative.
Now, you said
It's a direct
you
question.
did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3
Totally toast.
what you thought to be black males on the porch of the residence there, correct?
Objection stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay,
And then on the porch, there was maybe 3 or 4 more people. I don't know if they were, I'm sure they were white, but
okay.
I was trying to not make it obvious because at the time, I believe that they were with the vehicle. So I didn't want them to see that.
Oh,
I
Joe
saw
Nathan,
them.
I'm drinking after this.
That's what I thought was right at the time.
That is a fact. I may even start
Do you
before
happen to
this is
know
over.
people that live at this house?
Objection speculative.
Overruled.
No, I did not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection. There was never any crash mentioned.
I'll sustain. Calls for speculation.
I mean, unless you want to
Mr.
count
Lescano, is
mowing
it possible
down.
that the people you saw standing near the
countless
vehicle
people.
were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety, just like you were, correct?
Objection speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection Speculative.
Overruled.
No, that's an eyewitness.
You said
Totally
that.
sure
Characterizes the
that that's
testimony.
your ass.
That was not testified to before. Direct.
Oh, your objections are
That's not
overruled.
speculative.
Believe the
That's
witness already.
that's your
Mr.
ass sitting in that chair, dude. You.
Did you happen to notice in Exhibit 65?
That's his witness
the red
too.
SUV
Like
in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it.
you?
you didn't count on the cross, did you, homie?
Mr. Liscano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case or your testimony?
Objection, hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection, hearsay.
Oh my God.
Overruled.
No. Man.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
Yo, his first prison tattoo should be like overruled right there on his neck. Bam.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No.
I mean, he's shutting down
the profile, the side. You were flying fast down that street. I wasn't paying attention to the colored clothes you were wearing. I knew it was a black male and had a scruffy beard.
What the hell happened to the
First thing I
camera?
told my wife is he was a black guy driving.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
No, it had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah.
Yeah. Like,
tell if you were white or if you were black and if you had a beard or not. That's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
how much clearer can I make it that I saw your dumb ass?
So that leads back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
I took care of it, Beastly. Thank you.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this
Yeah, so let me correct myself. When you were hitting the people.
to both detectives, two different detectives, the evening of November 21st, 2021. And this was in relation to what you saw.
He doesn't seem to have one,
at the
Caribbean
parade,
Kool-Aid.
Not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade? Why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
I mean, that dude could straight up say, I saw Santa Claus driving the car. And it wouldn't matter because he's on video.
November 21st, 2021. You also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
I don't remember.
No further questions.
Thank you, sir. You may step down. We have additional witnesses here.
Yes, Your Honor, they're ready.
All right, would that be how many people?
There's 2 left.
And I wonder how long his closing arguments are going to take.
Your next witness. Sir.
Like, God help us all.
So I'm guessing that's, oh, I know what it is.
Yeah, we don't know what it's like. He
One
doesn't
quick
seem to
second,
have
One
any
quick second.
specific defense other than his name being in all caps. And so he doesn't go by that name because it's not him. Can't be him because I don't spell my name in all caps. I mean, yeah. I mean, if you guys want me to keep going over this, I will. I mean, I'm not gonna do like the full day. I'm surprised I've been on this long. I mean, yeah, like I'll do maybe. Just depends on the mood I'm in, if I'm being honest. But if people will log on and watch, I'll cover it. Sure, you know.
Sorry about that, Your Honor. I'm just making sure I have the correct paperwork.
Laugh at life too. Stop it. Actually, I don't give a shit.
My jurors need to stand. Go ahead.
stuff is so much paperwork.
Okay, that wasn't me. I don't know what's going on there. That is a freeze on their feed, who I'm streaming. So I don't know what's going on there. Matthew Giannotti? No, that's not fair to say. I mean, common sense would dictate that if you intentionally mow people over with your car, you know that they're probably going to die. Yeah, so I don't know what's going on with their feed. I know, Joe Nathan, but the thing is I have to stream from a legitimate news source so that I don't get a copyright strike. Court TV will strike a channel. Law and Crime will strike channels. But if it's like Fox or CNN or CBS or, you know, etc., it's fair use, so I can stream them. But Law and Crime will strike you. And I mean, and I'll beat the strike, but they're bitches like that. Law and Crime sucks. They're bitches like that. So they've struck me before streaming a trial, and they struck Recollection Law too. But yeah, Court TV does a little bit too much speculation for me too. Like, I don't need to hear these reporters' opinions. Because I'm giving my opinions. All right, let me see real quick. Hold on a second. There we go. Thank you very much for that, Austin.
Bye.
Okay. Do you recall where you were positioned during?
Thank you,
watching
McCarmel. I got it.
Group participating in the parade?
Yes, on north and east, right on the corner there. If you're going parade route, it would be on the right-hand side.
Okay. Just so we have clarification, can we pull up exhibit, I believe it's 15?
Thanks, Kimmy71. Always good to have you in here. Appreciate it.
Thank you.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet. Just I want to make sure the witness gets a chance to view it first. Can you see that on your screen yet?
I do.
And using the touch screen, it's a touch screen. Can you point out where
It's not published.
Yeah, but Matthew, I don't think it's going to be difficult
Sorry, I
for
didn't mean to
the
interrupt.
state to prove intent.
Just wanted to point that
So
out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, and can you, using the touch screen on your screen, can you
point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching.
right on the corner, sorry. Oh, well, if you want to
Can you clear,
re-raise it
can you
again,
clear
I'll do it
the
again.
arrow?
We'll clear it. You can do it again.
And for those of you who follow the Gannon Stock case, Letitia Stock's trial begins
Clear it
in,
again.
Okay.
So it's a touch screen.
oh
So
man,
your
I want to
index
say
finger is in a
January.
circle.
So when that
I was gonna
happens,
say
I'll
that.
be
Well, I
covering
knew
that.
it was right there, but.
I was
She
gonna say a
did
circle or a little
say
dot.
that she was going
Well, I
to
thought it was a dot, but-
Yeah.
defend herself, but then she ended up getting an
Yeah.
attorney.
So,
So
press and hold.
hopefully it
while you
won't be
draw.
this
Okay.
shit show. But
There you go.
And
but it would be if she was defending
said that would
herself.
be,
I expect it to be just as bad as
approximately,
this, if not worse.
East Main and Northeast.
Correct.
And do you recall if those will there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from here?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? Would that be fair to say first? I don't want to assume.
Yeah.
He doesn't
Do you
want to
recall
assume,
anything
y'all.
happening at that point?
A situation did occur.
Right, Dorinda, because she's stalling.
Before
She's of the same mindset as this
big
guy.
event that took place.
She thinks she's smarter than everybody.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention?
Ultra
at the
Dark
time?
CEO.
Yes, a car.
And you will be
coming through the
doomed.
parade at the beginning
You will seal your fate.
on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has. And then continued on.
Did you see did you see?
McCarmel, I don't think
where the
that's
car
his
went at
defense
that point?
because everything,
Yes,
all
I
of his
did.
line of
As
questioning has
it
implied
came
that
around the slight
it was
curve
not
White
him
Rock
driving.
has,
He's trying to create
it
doubt in the
started
jury
move
to say that
forward,
it wasn't him
and then it
driving.
went
So,
straight across when I was thinking it was going to leave the parade
so I don't
route.
think that he's
If you
trying
leave the
to
parade route on Main, you're leaving.
use
Sorry,
lack
if
of
you
intent
turn
as a defense.
left, you're leaving the
Or at
parade
least
route.
he's
You're
doing
turning
a
right,
horrible
you're going
job
right
if
into
it
the parade,
is.
and it went right to the. If you're
I mean, he's
looking at
doing
the
a horrible
parade,
job anyway,
it's
but
on the right hand side, and it's continuing.
he's not
on
focused on that at
into
all.
the parade.
Hold on, just for the record, she was using her hand.
At no point is he going, well, yeah, I did it, but I didn't mean
I just need
to.
to make a
Yeah.
record of it. Usually her right hand, just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record about that. Go ahead, next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you
Oh,
might have
totally,
seen,
Matthew. Absolutely,
multiple
yeah.
people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while.
God, this guy.
Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
Now this isn't going to last much longer. I'm sure they're in Central Time, so right now it is 4:13 over there. So I'm guessing before 5 p.m.
I did not.
their
I don't
time.
recall. I'm sorry.
This will be over for the day. Exactly, Austin. He needs to go down for a nappy time.
And
He needs his
recall
baba
if the vehicle was speeding at that point that you
and his
observed it?
It
binky.
wasn't speeding, but it was, all I can state is it wasn't speeding.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have clipped me or the two people that were in front of me.
Where you were, the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you.
I mean, she might want to just get through these witnesses today, man.
You
Just
testified on direct examination.
right
that
now,
you
things
don't
are finally
recall
moving. You know what I
whether or
mean? This is
not
the first time in the
more than
whole
one
trial
person in
that things have been
vehicle.
moving at this pace.
Saying that?
So
You remember meeting on December 2nd, 2021?
I think
for an interview
he's
with
worn
Detective Jay
himself
Carpenter from
down.
the Waukesha Police Department.
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection.
Yeah, I
Overruled, you may answer.
It's
I can't
Cross.
be sure.
Overruled, you may answer.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I might have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
And I'm digging this guy. He's a no bullshit dude.
Testimony is that you were standing here on the northeast corner of Buckley and Main Street. Is that right?
Objection already answered that, asked and answered.
Overruled, you may answer.
You said correct.
Correct.
And after your children walked by in the parade. You walked in this direction towards the intersection of White Rock and Main. Is that correct?
Objection
Correct.
leading and speculative.
So the rule is to both, you may answer. If there is another objection, just
I'll
wait
pause.
until I rule on it.
Sorry.
Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street. Is that correct?
Yes.
Is that when you saw the
No,
we've been talking about?
Catherine, they've got him on video.
So you were standing in the crosswalk.
Correct.
Do you remember a police officer being in that intersection?
I can't.
They've got him on video. They've got
Was it clear to you
a
that this
still
was a
of
parade
his
route?
Yes,
face
it was
in the
very
vehicle,
Was it clear
and
to you
the
that
vehicle
traffic from White Rock should not
going
have driven
through the
down
crowd.
Main Street
Yes.
unless they were part of the parade?
like it doesn't get any more proof than
Is it
that.
clear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Darrell?
Objection irrelevant.
Overruled. You may answer.
Well, let's not call it an accident. But yeah, I think that's what happened. Yeah.
All four of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled.
Sorry.
Your oldest daughter, Charlotte, she was 14 at the time.
Yes.
She was marching with the Extreme Dance Group
God.
as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection. It's overruled.
Oh my God, this poor lady.
Well, I was subjective, but we still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Oh my God, dude.
Okay, I'm sorry.
Objection
This
hearsay.
poor woman. Oh my God. I didn't know that her kid got
I did not.
hit.
Did you see them later that night?
Objection leading.
Overruled. You may answer.
Oh my God, this poor lady, dude.
I was only able to see 2 of my children that night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care, the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled. You may answer.
Yes, their father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Oh my God.
Sorry,
Leading.
Overruled.
Oh my God.
You may answer.
she did.
So is she paralyzed?
Your daughter Alice, she was 10 at the time, wasn't she?
Oh
She was.
no.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Oh my God.
Yes.
Jesus Christ.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the Extreme Dance Group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Overruled. You may answer.
Yes.
And road rash
Extreme road rash.
Oh my
and a
God.
lung contusion
Oh my God.
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Objection
correct.
leading.
Overruled.
Oh my
He was
God.
walking with the Extreme Dance Group, handing out candy. Is that right?
He was.
They were handing out
He went to
candy.
the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection hearsay. I don't believe he's a doctor.
Overruled, the witness may answer based upon personal knowledge.
The fucking balls on this guy,
Yes.
dude. Oh my
Police
God.
officer
This is infuriating.
saved Grayson's life by placing a tourniquet on that open leg wound. Is that correct?
Yes.
I don't have any other questions.
Dude, if he,
No redirect.
yeah, shut the fuck up. Good move. Let that lady go home.
You may call your next witness, please.
Yeah, is it hitting you now, motherfucker?
So we're gonna take down these exhibitors. You're gonna stay up on there.
Thank you, we'll take it down.
Yeah, because it's all about you. God forbid you have to see your handiwork. Look, he's not taking his eyes off of him. Like, that poor lady in the middle.
Please call your next witness.
Just 1 second.
Yeah, she wants to move this along. She wants to get through these witnesses and throw this fool under the prison. All right. Well, it's 5:30 here, bro, so
So you one more person here, right?
It's my understanding, sir.
cheers.
Would that be correct, Attorney
Yes.
Hopper?
Yes, she's in the courtroom, ready to go, Your Honor.
Yeah, I don't know how long she I know that she tries to wrap these things up before 5 o'clock their time, but I am of the impression that she's finally got some momentum in her courtroom of things moving along, and I think she wants to ride that
I don't
momentum.
know how to say the last name.
Can you give me the spelling that you have?
Babiasz.
It's Babias. What's your last name? Babias. All right. Thank you. You are at the witness stand. Would you please raise your right hand? My clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Catrice Babias, Katrice Babiazz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Babias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of
November 21st, 2021. Were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling and the vehicle.
See, she's
the
in law
driver was
enforcement. She
honking
knows that
the
it's
horn.
effective to look at the jury when she's answering questions.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn. Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained is to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Okay, there you go, Matthew.
Do you back up? Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did the driver look?
Like you?
The driver looked like through me.
What do you mean through you? Describe what you mean by through you.
Well, he's
I
asking.
feel that it is very hard to explain that look.
She's asking. He's asking for a
but it was
description.
very
That's not what he's
frightening.
asked. I'm gonna rewind that just because I don't want to be disrespectful to her answer because I was talking over her. But
It was very frightening.
sorry.
Do you recall what the driver was wearing?
The driver had a like hoodie sweatshirt or sweatshirt on and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
Heck, a party of six. I'm gonna have to disagree with you because they gave me a
The
jaywalking
hair
ticket
on
first
the
of all,
head was in
and then
front
took me to
with
jail for
threads
not paying
down
it.
here from what I
So-
could see underneath the hood or the hat. And then there was facial hair.
Fuck
Beard
Cobb
and
County.
mustache.
Did the
Hold
vehicle?
on, I just need to make a record of, she was also using her hands. That's okay. to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Yeah, I lived in Cobb County. It was like right by where I live. I crossed that street all the time. And then the dude gave me a ticket while he was harassing somebody else because I didn't use a crosswalk that was nowhere nearby. He said, sit down right there on that curb and I'm going to give you a present because I'm sick of scraping bodies. You're playing Frogger. That's what he said to me.
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes.
Man, fuck that guy, Julie. Don't get me started.
Do you recall what agency that was?
I'll rant and rave about that
I
shit
do.
all day.
And what agency was that?
The FBI.
No, it's not already a mistrial. You're playing Frogger.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Yeah, let's not start a debate, Linz. Like, we know it's not a mistrial. Let's let's not start an unnecessary debate in the chat over what a mistrial is and what it isn't. We all, the majority of us, know what a mistrial is.
It was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Oh, Linz G, I was just speaking so that it doesn't happen. I'm not saying you were. I'm saying let's avoid it.
Here
Don't get so defensive.
You stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
And how great is it? Like, let's point something out here. How great is it that the person who got the best look at him at the moment of the crime taking place happens to be a dispatching supervisor for the police, which makes her a very credible witness to begin with, on top of the fact that she knows exactly how to deliver her testimony if need be. She's looking at the jury. I mean, that is just lucky.
Let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle?
Yes.
Yeah, reluctant healer. Yeah, like why does he keep like the fact that it's his witness blows my mind.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Oops.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
That's a good point. As much as I don't like it.
Because I haven't wanted to talk about the traumatic experience that I went through for
Good answer.
still reliving.
There you go.
The weeks and days after the incident.
There you go. Good for you. That's how you answer that.
It doesn't make any sense. You talk to FBI
Oh, and he's going to attack her.
days.
He's going to attack her.
You said you
He's
didn't-
attacking his
you
own
said
witness
you didn't
right
know. You
now,
said it was
people.
that week,
He's attacking his own witness.
the same week. You spoke with FBI agents. Reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement?
Dude, even
seeing
if
as
you
how
got knocked
yourself
down by somebody running away,
working law enforcement,
that counts, in my
Just
opinion.
seems
Anyway,
odd.
I don't know, but I feel like that
I did
counts.
not. I was not physically injured.
Oh, she wasn't physically injured. So what? Wait, lady, come on! You were doing so good. You were doing so good.
but you didn't report this at any time whatsoever. Grounds.
Sustained. Already answered.
So did you speak to anyone about this?
Right,
In law
Toast. I mean, you know,
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
I mean, but she's being very vague for the jury, though, you know? But she could also be trying to word herself carefully because she knows that
Following any
she's
claims
his
related
witness.
to the incident?
No, I did not.
I mean, I don't know. I'm just thinking out loud. So this way he can't say later that she was coerced by the prosecution or anything like that. I don't know. I honestly don't. Right. Well, Reluctant Healer, I do appreciate you being here, but you can watch this on
So
WISN
today,
12.
your
They're
first
live.
time,
That's who I'm streaming it from. You won't get any you won't get any commentary over it.
bringing up your alleged injury.
No, it is not.
Just saying.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
There you go. Okay. So yeah, we're talking about PTSD or, you know, obviously mental or emotional
Contacted
trauma.
The Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
You ever spoke with anyone directly at the district attorney's office?
No, correction. Yes, when I walked in today, I met there and let them know I was here. And then they walked me into a room and I waited until I was called.
That's not good. Ask if you
before
talked about the
today, you had,
case.
No interactions with anyone related to the district attorney's office besides I think you said victim advocate.
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Now in cross, I think what's going to happen is the prosecution's going to ask if
this table had you had any interactions
here we go
of any kind with any of those three district attorneys.
I have not.
And I believe just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
right, trying to specify for the witness any of us is what he
Working
means.
in law enforcement for 6
They're like helping him
years,
out. They're
I'm
holding
sure
his hand
isn't
through
your
this.
First time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
I have not.
Have you ever testified in any way before today? Browns.
Overall, she may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
Want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching,
when it was,
question was when it was approaching.
I'm confused.
Hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question
okay.
that as you understood it.
Yep, so I saw that an officer have to get out of the way. And he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name.
Y'all stop.
For the first time
Stop
that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name, Mr. Brooks, for the first time since you've been testifying. Is that fair to say?
Ooh.
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
Uh-oh. She threw him off. She triggered him. He's triggered.
I didn't need to.
So what changed for the last question that you needed to?
He's triggered.
I don't understand your question.
There you go. Get combative with your own witness.
You just
Good
stated
job,
that
buddy.
You
Real
didn't mention
smart.
the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
They're like, is he fucking like getting combative with his own witness? Is that what he's doing right now?
Out of curiosity, how did you come to the knowledge of that?
So
name?
stupid, this guy, dude.
It was on the subpoena I received last week.
You just stated a little bit earlier in your testimony that you received your subpoena in July.
No, she's not doing nothing wrong.
Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
Oh.
So the one that you received from the district attorney's office in July didn't have a case caption on it.
Did it say Mr. Brooks on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor. If I may have.
I have to look up case caption in my glossary of my law
There
textbook.
was no objection at first.
There's a. I'm going to sustain the objection under 906-11. I don't believe it advances.
I think
The trial.
I think you know where I was getting at with the question.
Yeah, we all
You
do.
need to
Like,
ask your question
yeah,
directly, sir.
Mr. Brooks.
Go ahead.
Mr. I don't go by that
Sustain it
name.
as to the form of the
That's
question.
we all know. We know where you're going, bro.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained, you don't have to answer that. I sustained the objection on those grounds. Ask the question, I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection, relevance.
Grounds.
Oh, sustained,
Grounds for the sustained. That was
not
the-
relevant.
What? Mind boggling.
Well, technically, Nikki, he doesn't go by Mr. Brooks throughout God knows how long in this trial. So,
Sir, in July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained, not relevant.
She's testifying in the trial, and it's not relevant that she got subpoenaed?
it's not the trial that's not relevant, bro. It's your stupid ass questions.
You called her as a witness. It's
The
your
subpoena that you, the
It's your
subpoena
witness, dude.
is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906-11, please ask the witness a
This is
relevant
mind-boggling.
and probative question.
This is mind-boggling.
It's clearly mind-boggling to you, my friend. Clearly.
Remind the jury that the statements of the parties or the attorneys are not evidence.
Wow. Okay. Yeah. Okay. Because that helps.
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained,
Grounds for the
relevant.
sustained.
it's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
I think
Brooks,
that's
I'm
very
sustaining the
relevant.
objection under 906-11, and I'm asking you to move on.
It's not relevant to the line of questioning, dude. It's Oh, shit. I'm coming down with COVID, Your Honor. You hear me? I'm coming down with COVID. Code red. Mistrial.
Seems to me like a like a lot of your answers are coached. Is that fair to say?
Oh my God, this motherfucker
No.
right here, dude. Oh my God.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued. before.
Grounds.
Asked and answered.
This poor dude.
She indicated
This poor dude on the far
the
left,
answer
bro. Like,
already. 906-11, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked to answer. Oh my God, bro. That was not asked nor answered.
Under 906-11, please ask a question, sir.
Man, what is y'all people trying to pull up? Man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611.
What is y'all
then I
people
will
trying to
turn the
pull?
Witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 90611, you're directed
my
to ask a
God,
question,
dude.
or I will
I
ask the state if they have
heard
any
you, Your Honor.
questions.
I heard you. I heard you.
Wow.
Next question, please.
All right. Fuck my life, bro.
You know who the plaintiff is in this matter?
Yes,
Who's the plaintiff?
the state of Wisconsin.
Is that an entity or a living human being?
Oh my God, he went there. He just couldn't resist.
Have you ever had any interaction with the plaintiff?
Sustain
Vague.
Vague.
the form of the
Have
question.
you ever had any interaction with the state of Wisconsin?
Do not answer that question. Next question.
The
sir.
people on that
Under
table right there
90611.
represent the state of
Is there an
Wisconsin.
objection or
That's
was
how
that
it works,
just a
homie.
ruling? I'm not sure.
They elected officials. Well,
Under
the DA
90611,
is an
I
elected
direct the witness
official
not to answer
elected
that
to
irrelevant
represent
question. Ask
the
your
people
next question, sir.
of Wisconsin, who are the plaintiff. Dickhead.
Mr. Brooks, ask your next question.
I'm gonna get to it.
Oh
Thank you.
my God, dude. What? I'm gonna get you it. I'm gonna get you it. That's my bike, punk.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
90611, sub 1, sub A, sub B, and sub C.
is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
They're like, should we? I don't know. Like, what do you think we should do? Should we just like make him look like a total fucking asshole right now? What do you think we should do?
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy?
and
Overrule, the witness may answer.
Of course it's gonna be overruled.
3 and 6.
He's getting hangry.
I don't know.
He wants that
Mr. Brooks,
that state issue bologna sandwich already.
Ask any questions right now.
Mr. Brooks, please sit down.
Am I
Mr.
still
Brooks,
gonna
you're
get
not
dinner
asking the
tonight?
questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state.
No, it's
Yeah. The one you
not
traumatized.
doing anything wrong.
Asshole.
Merely standing here.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their question.
So how
Go
come when
ahead.
I did that,
Overrule,
it was
the witness may
it was
answer.
abstain?
I was
What's up,
on
D-Lan?
Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
Yeah. And cross-examination on his witness,
And I asked them-
we're gonna present some evidence that you're gonna testify on, okay? Just
And
kind of
then
how it's
this
done.
Shall
Show
wait till it's in the jury
I'm
box.
sorry.
I'm sorry. The jury would let me know when it's there.
Thank you, it's there now, go ahead.
Ma'am, do you see a purple line on that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle.
He sure didn't, Sherry. Sherry XO, he sure did not have this energy
Would be fair
for
to say
the
is
hairdresser.
to your left would have been Pleasant Street.
That is correct.
Were there barricades blocking Pleasant Street?
There were
Overruled, the witness may answer.
there were barricades that were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Overruled, the
Hearsay.
witness may answer.
Dude, if this were a basketball
When the red
game,
SUV
the
came down
prosecution
White
would
Rock
be the
Avenue and was
Globetrotters.
making its
They-
turn onto
They would
East
be
Main
like,
Street, as you testified. It could have just gone straight on Pleasant Street.
they would be like
correct?
spinning the ball right behind his head, and then
hold
like,
on.
and then
Um,
like passing it to each other and dunking.
Mr. Brooks? your
They would have
objection
pulled
is
his shorts
noted.
down,
It's
made the crowd
overruled.
laugh.
The witness
As
may
usual.
answer.
It's always overruled.
Where's the ball? I don't understand where the
Go
ball.
ahead,
Oh,
you
it's
answer
already
it.
in the hole. Shit.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
This guy
Overruled, the
is
witness may answer.
clearly a misogynist. He hates women. He has to
Can
be
you repeat
combative
it?
with women.
Were
He
you and your
can't help
kids,
it.
all in the roadway when the red SUV went through?
Yes, we were.
Okay, you weren't part of the parade, correct?
We were not.
Okay, so were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection,
daughter.
speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
Yeah, she looked you dead in the face, stupid.
Objection is noted, it's overruled, the question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade, is that correct?
Yeah, we saw Santa, and he's always like the end of the parade
And had your daughter gone to get candy at other times?
the entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was-
Totally, Matthew. Totally.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled, the witness's answer may stand.
you see this red SUV coming, is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Thank
Did you not
you
pull
for
your daughter
Darrell
away with
brooksing
that
my
card
chat,
with your daughter?
Joneson. I appreciate it.
Overruled.
It's very possible.
We all enjoy when people Darrell Brooks my chat.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one was where we were on Main and White Rock. And then there were also other people trying to stop it too.
Wow.
And then again, as it drove, once it turned onto Main, the next road, I believe it's Buckley, and there was another officer who tried to stop that, the Areta Civi again.
And which is the officer who had to step out of the way in order to? not
Oh
get
yeah,
hit
Matthew,
by the
he's in
Areta?
custody. Yeah.
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled.
Yeah,
the
that's
witness
the
may
that's
answer.
the allegation,
The
McCarmel.
direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you
Dri-
describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Right. So the crowd probably, red
Nothing
seed for
Thank
for
you.
for a lack of a better term. They
You read
and
the
then
restaurant.
came back together as the car got past behind the car. The crowd probably came back together, and she lost sight. So that makes sense.
You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one that I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
Cartographer,
The interview
ultra dark CEO,
that was
a
conducted
cartographer.
with FBI. That was who did your interview, correct?
What they needed
Yeah.
was a carologist on the stand.
Why was there
A
no-
vehicologist.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why it wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that it
Shit, he
means
just
that
spread his COVID. God damn it.
some details you don't quite recall all the way. That be fair to say.
Yes.
So it'd be fair to say that if there's details you don't recall, how can you recall path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask you.
Wow.
You just acknowledged that there may be some
This guy just has to
details
fight
that
with
you
women.
don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Yeah, because she pointed it on the map when she was cross-examined.
Judging by
The map that showed the
what
direction.
you just stated, wouldn't it be fair to say that that's a possibility?
No, it's not a possibility, dude.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
How does someone recall the details that they don't recall?
Yeah, that's what I wanted.
Sustained
How
is
do
to
you
the
recall
form
some
of the
details
question.
that-
I can't believe he just said that. And the fucking prosecution just busted out laughing.
As if
Prosecution. Oh my God, this dude is something else, dude.
Want to recall and purposely not. recall.
Objection,
Don't.
badgering the witness.
Yes, sustained. You do not
Badgering.
have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue. What do you mean?
What you just did,
Next
dickhead.
question.
What do you mean?
Oh,
Don't
so let's argue with the
intimidate
judge
witness
some
is
more.
What I mean.
How
Good
am I
job.
intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements.
Get him.
Regarding
That's
her
inti- does she
answers
feel
Get him.
is badgering the witness.
Get
Are you
him.
kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious right now.
Get him.
Intimidating the witness. What have I done to intimidate the witness?
The last question.
It's
was
an animal in
badgering,
the
which is a
forest,
form
Toast.
can
But you
be.
said
Mr. Brooks, I've
intimidate.
made my ruling under 90611.
specifically said
Please
intimidate.
ask
I think
the
there was one
question
in
or
Bambi.
I will
I
stop
don't
the
know.
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your
Get
next
'em!
question, or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step
Wow.
down now. Thank you.
How are you even a judge? Come on, man.
Look, homeboy behind.
This must
He's
be all about the
homeboy behind him is
citizens
like,
you trust, right? That you want to be the beneficiary of.
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports.
she deserves, that judge deserves a foot massage after this.
Other electronic application or tool
And
this trial. Do not
I don't even
consult
care
experience,
if
computers,
the person
electronic
giving it doesn't
applications,
like feet
social media, the
and she's
internet,
been
or other
sitting down this whole
records
time.
for additional
I don't even
information.
care.
Do not seek information regarding the public record.
I don't
of
like
party
feet.
Or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools.
Ultra Dark
with
CEO, thank you.
capabilities to share any information about this case. For example, do not communicate by telephone, blog posts,
Witness is
email,
not a badger. Mistrial.
message,
Right.
social media posts, or in any other
Not
way
gonna happen.
on or off the computer. Do not permit
They
anyone to
totally zoomed in
communicate
on his
with
face,
you
Toast.
about this matter,
They totally
whether in
did.
person, electronically, or by any other means.
Yeah.
If anyone does so despite
Oh, the COVID. The COVID.
report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must
I
be
got all the
decided by you,
strains.
the jurors,
I got
based on
all the
evidence
strains.
presented in the
Every
courtroom.
strain.
People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe
Come on,
that
say
another
something.
juror has
Say
violated
something.
these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving.
Look, he spread the COVID all over the courtroom. Everybody's got the COVID now.
You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
Way to go, Judge. Way to go, Judge. She took her courtroom back.
Call yourself a judge as much as
Come on.
bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None.
Yeah, says the guy that mowed over people maliciously, carelessly,
None.
every listly there is.
Thank you, everyone. Please be seated.
Oh, so you're not going to sit down.
I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and
Is he
obviously
supposed
she
to
can appear
to
here
sit down as well,
voluntarily
or
if,
is he like trying to
Mr.
pull
Brooks
like a
wants to
reverse
arrange that. I don't
Kaepernick
believe
thing right now?
subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to
Boom.
worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
Wow.
I agree with the state that
Wow.
she could certainly appear.
It ain't even got to be no arrangement. All I gotta say is come. She gonna come.
Wow, dude. Yeah, no,
That's
you're
it.
not a controlling piece of shit when
Mr.
it comes
Brooks,
to
do you
women.
intend to call her as a
Okay.
witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that- We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks,
Tie the noose, homie. Tie the
I need
noose.
to make a record too.
Tie the
When am I
noose.
gonna get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so what
down
do it matter?
for
You
the
can
better
hold me
part
in
of 2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding you
gotta
in
do is
contempt.
if it's
Not
criminal or
doing it.
civil, so
I'm
I can
playing
give you
chess,
what you-
I need
fool.
to clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what is
He is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to
Mr.
the
It
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
Boom. Woo! All right, I'm gonna leave that up just for now in case some shit comes back. I don't think it is, but if I picked any one of these days to cover this case, it was today. It was today. I am in awe right now of the madness that I just saw. The absolute, complete, and total disrespect of this courtroom, of that judge, of that witness, of the prosecution, the entire proceedings. But I saw the judge take back her courtroom today. I want that on the Glera record. Okay, on this channel's record, what I said prior in my last live about this case was that the judge had lost control of her courtroom, and I still believe that she did to a certain degree. She did, but she had to, in order to keep him from weaseling his way to getting a mistrial and to be held in contempt. He's trying to bait her into a position to where he can appeal. And she took control of her courtroom without giving him that today. So good on her. Listen, y'all. Well, you know what? I'm gonna hang out with you guys just for a minute. Just for a minute. Look at some of your all's comments. Let you guys speak your mind in the comment section before I wrap this up. Killer Brooks. He hasn't even stated what that. I was always waiting for that too. When you say, what name does he go by? He hasn't said that. There's never been a correction. He's always been like, I don't go by that name. And then when asked, what name do you go by? He diverts from the question. Yeah, we got that, Joneson. We got that. I don't like you, but, you know, I'm glad you're covering this. Whatever the fuck that means. See, this dude, he cannot. I don't think that he can. I just don't think that it's not proof in a court of law that he's physically abusive towards his ex who was on the stand, that she claims that he is, but it's apparent to any of us that have seen abusive behavior that this guy is abusive. He's clearly abusive. And the jury saw it. The jury saw it all. This dude just nailed his own coffin. She does, man. She does. Like I said before, I stated before, I was lucky enough the last time I was covering this, I was lucky enough to have an attorney in this chat. Her name is Mystery Maven Esquire, and she was very helpful in providing insight in the chat. She was great. And she explained to me, because I was just like, man, she lost control of the courtroom. This is ridiculous. I lost all respect for this judge, blah, 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 blah. I went off. I was really frustrated with this guy, just like most of us were. But she explained about how she's being careful and not allowing him grounds for an appeal. She knows he's going to be done, but she's being very careful of not allowing him and giving him grounds for an appeal once he's convicted. And I don't argue with it. If I'm covering a trial and I'm talking about a trial that I'm watching and an attorney shows up in my chat, I'm just going to be grateful that that attorney is giving me insight, and I'm not going to argue the law with a lawyer. So I was like, yeah, okay, I got it. Now I'm really seeing it. I'm seeing exactly what she's talking about, what she was talking about. So make sure to subscribe to Mystery Maven Esquire. Like, I'm so grateful to her for her insight. But now I'm really seeing it. And blaming the baby mama for lying about her age. Yeah, get the fuck out of here, dude. Julie Porter, I mean, at least a few minutes. We'll see. Like, I started drinking, so I'm not trying to get like hammered and go on an 8-hour live here. That's not going to happen. Like, I just opened I had this bottle open. I just, I've had 2 glasses out of it, and this second glass is still half, at least, like 3/4 of how much I filled it. So that's how much I have here. So actually, I'll give you guys this much time. Based on how today went, Julie Porter, yeah, I think I'm going to keep going with this. Absolutely. I think I'm going to keep going with this. You're not getting drunk, Will, tonight. This is not going to get me drunk. That's not going to happen. Dude, I hope, reluctant healer, I hope she's drinking tonight, man. I mean, if she doesn't drink, I respect that. Whatever she has to do to like reinvigorate, whatever she has to do to recharge, because that has got to be the most draining shit. I don't think any judge, I know for a fact that any judge that I've ever seen on a high profile case has ever put up with what this judge is putting up with. I've never seen that shit. I've never even heard of that shit. And this is a crime community, people, right? Think about that. What high profile case can you think of that everybody talks about in this community that judge has ever had to go through? I've never seen it. That woman gets all my respect. I mean, he's not lucky he's given a fair trial. Let's not, like, I like to choose my words carefully when it comes to things like that, and I'll pick apart words in chat. Like, it's not that he's lucky that they're giving him a fair trial. It's his right to have a fair trial. It is his right. What he's been doing is manipulating his right to a fair trial in order to troll, to annoy, to piss off, to frustrate, and try to wear everyone down. And that's why I started cheering when I heard him go, I'm done with this. Just get me out of this fucking courtroom. I'm tired of it. He's the one that got worn down. That's why I started cheering. That's why I reacted the way that I did. Because he's the one that got worn down. His strategy backfired on him. Well, oh, Sherry, that's why we're not judges. You know what I mean? That's why we're not judges. Yeah, Austin, I swear, I think he just got hangry. I think he just got hangry. This dude straight up got combative with his own witness. Like, he did not do any research. He did not do any preparation on what he was going to do with that. And the last thing that he expected was that his own witness was going to go, you looked me in the eyes. You looked past my eyes. And I'm still traumatized from it. He did not see that coming. Why? Because it's all about him. It's all about him. Yeah, this is a guy who spent his life arguing with women, fighting with women. Because you're right, he did not have that same energy. Somebody mentioned that he didn't have that same energy when the hairdresser dude was up there, the one with the seven convictions, 7 times. The last one being back in 2007, if I remember correctly. But the last one being in 2007, and this dude is just a family man now, trying to do his best. This guy probably got sick and tired of doing shitty things and being around people who do shitty things. So this was very personal for that witness because he was with his family attending a parade. You know, like, this isn't a dude that's out, a piece of shit that's out looking for trouble. This is a guy that was like, what is the most purest thing that I could be doing with my time right now? Oh, there's a Christmas parade a month before Christmas and I'm going to take my kids and my wife to this Christmas parade. That's what he's doing. And he's cutting hair for a living. And he says hairdresser. So that means that he's probably like the thuggest Zoolander, not Zoolander, but oh man, what was Adam Sandler's name in that movie? Oh man, what was the name of him, dude? That character. It's a funny ass Adam Sandler movie too, and I hate Adam Sandler. Well, I don't hate Adam Sandler, but I'm very picky when it comes to Adam Sandler movies. Zohan, don't mess with the Zohan. Zohan. This dude is like this dude is just like I couldn't help but picture this dude in like a high-end salon, right? In like a high-end salon, just yanking somebody's head back and getting those 2 fingers full of hair and oh yeah, word, letting them talk about life. Yeah. What you think? Hands him a mirror. What you think? Does it look good? And then it's this gorgeous woman who's probably a professional model because he's a hairdresser, not a barber. He's a hairdresser. And she's like, oh my God, you are magical. I'm telling all my friends about you. Dude, that's the toughest dude on earth. Totally secure with his masculinity, everything. Like, and he was looking him dead in the eye that entire testimony. I loved it. He was like, I saw you. Oh, the Zohan movie, what I remember most about the Zohan movie, and this is not to get too off topic, but I remember Dave Matthews did a cameo in that movie, and that was like the only thing about Dave Matthews that I like to this day is because Dave Matthews is a funny guy. But God, man, if you guys want to torture me, like play any fucking Dave Matthews music. Yeah, like the dude with the 7 convictions. He's a hairdresser, according to him. That's what he called himself. That's what he calls himself. Totally secure with his masculinity, because a lot of dudes that are trying to establish being tough guys are like, no, man, I'm a barber. I'll line you up. I'll fade you up. But they don't say hairdresser. A hairdresser like makes women pretty and takes pride in it. That dude had all my respect in the world. Yo, I'll put you on timeout, Calamity Jade. You're lucky I don't even know that goddamn song and I can't hear the music. That's why you're not getting timed out. I know you're trying to troll me. No, I mean, I don't think he can call any more. I don't think that he can like list any more witnesses. I think that he has a list of witnesses. They've been subpoenaed. That's how it's done. And there's only a couple to go through. If any more. I don't even know how many more there are. But the judge did a good job of keeping things moving. She took control of her courtroom. He called his witnesses. That's it. After that, from what I understand, after those witnesses are done, it's closing arguments, jury deliberation, sentencing. Done. Whatever, Calamity Jane. That shit don't mean nothing to me. Fuck Dave Matthews. Oh, wait, whoa. Really? Oh, really? Yes.
Instruction conference.
Let's rewind a little bit.
It's my whole instructing ready of trial.
I just don't want to miss anything here.
His or
Hold
her
on.
own
I want to hear what
defense.
she has to say.
Of course,
But she's
that
been
right
talking for a
stems
minute.
from various
Hold on.
constitutional provisions, including really loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11 sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called.
His witness.
Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections. That is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday uses, it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures.
I'm reading the Bible, y'all. Hey, Jerry, can you see me reading the Bible?
It was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police report.
His witness.
And obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which there is, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows.
Don't you know?
Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include
Now, what are the
reference
rules
to whether
as
he's been
far as
convicted
him
of crimes
testifying
in the
on his
past.
own
I
behalf?
still need to make a
That's
ruling
what I
on
wanna
that, and
know.
I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone
Oh,
has
I
made any
totally think he
promises
will.
to him to influence his decision.
I
to
totally think he
testify.
will.
I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education.
I mean, maybe he won't. I don't know.
I will ask him whether he
It wouldn't be in his best interest.
medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects the defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004, Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146, Wisconsin 2nd, 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions.
Hey, I put up this poll.
Citing to Rock versus Arkansas,
Please vote.
Balancing test that
Take a
if
second
and
and
when this
vote.
court is faced with any of these situations, that I will be.
I want to get
prepared
as
go
accurate
through.
of a result as I can from
Of
this chat.
course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted.
Yo,
previously.
McCarmel, you better take that dog out. I even stepped away from my own live
Heavily, of
stream to
course,
take my
during
dog
the course
out.
of this
So
trial on 90611. And the primary
you better
purpose
take
of a
the
criminal
you,
trial
you
is
better
to
take
develop
that dog
relevant
out.
facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes.
So I guess they got through all the witnesses, right? That's what it sounds like to me.
Tying
Like
up, I guess, the last
now
loose
she's like
end.
establishing,
I've
okay,
referenced it already, but I think it's worth.
he has the
repeating
option.
Again, if the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen.
Okay,
Either
there's
he
another witness
testifies first,
possibly.
or he doesn't,
Possibly
or he
another
calls.
witness.
He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks, and I expect people to be on time.
On time. If you're 1 second
and,
late,
to be ready. To
we're
go,
moving
to
on
be
with
fully
this.
Prepared, and then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of right now, Your Honor, just so you know for timing.
Thank you. I appreciate that. Because once the evidentiary phase of the trial is
Welcome,
closed,
Angelica.
of course, I will be sending the jury home because I do anticipate
for
a very
subscribing. I
lengthy
appreciate it.
jury instruction conference. And it's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes with the hope of, and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard on pulling together just something we can get done by the end of the day on Monday, but since it's a very lengthy jury instruction,
So you know for timing.
thank you. I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference.
Wow.
And it's my hope that that is
Like
something
how
we can
lengthy?
get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes with the hope
Okay,
of,
so
and with the plan of,
the plan of
again,
it being
assuming the
one
state
day.
doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process.
Okay, so there's this
We have
jury
been
instructional
working-
thing that's going to happen. It's going to take a
Clerk has been
while.
Working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes. with
No,
my
Salty,
advanced
that was a
eyes,
while
I
ago.
need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done so I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first. So the state should be prepared perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions, and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now.
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries
It's
of
getting
those
dark.
witnesses'
I
statements
had to turn on my light.
as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Miss Aldrich's statement to the
Thanks,
Waukesha
Joe
County
Nathan.
Sheriff's
I
Department
appreciate you being here
as they
consistently
were
as well. You're
memorialized in supplement number
consistent. I
55
appreciate that.
under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably
Patience, Salty. Patience, darling.
what I believe to be the defendant and Miss Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born.
Wow, Joe. Thanks, man.
May 1st of 2022.
Appreciate that.
I think that there was ample grounds for the court to end Miss Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Miss Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls.
Wow!
Finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
What? Boom! Okay, so y'all remember what this is, right?
Being made.
I'm going to pause this. And
Mr. Brooks
we're going to
and
spend a
ask
little bit
him
more time together.
There's
But
anything.
I'm going to pause this real quick. Now, you understand what that was? If you guys have been here from the beginning, a lot of you have been hanging in with me for the last almost 6 hours now. There was at the beginning of this stream, there was the X, okay? The one that he was convicted of impregnating, and she was a minor at the time. Okay. Now, he was trying to say that she was contacting him and writing him letters, right? She was trying to say that he was contacting, or that she was contacting him, writing him letters, sending him pictures. That didn't happen. According to this, according to what the prosecution is saying right now, what they're saying is that he has tried to call her from the jail 27 times, 27 motherfucking times, and she declined each call. Now, this is all on record, people. This is all, well, not on court record, but it's all recorded. It's all evidence. Okay? So he tried to discredit her as a witness, but, dude, my man, dude, really? Really? Are you kidding right now? He tried to call her. He tried to say that she was so afraid and claiming to be afraid, but yet she's contacting him, right? That's not what happened. According to what the prosecution is saying right now, they have proof that he tried to call her from jail 27 times and she declined. Was it 37? Did I hear that wrong? I don't know. 37, 27. Who gives a fuck? The dude's a fucking liar. Fuck him.
He needs to make a record of at this point on the topics that have been raised.
Oh, here we go. Here we go. Here we go. I wish my man Monty was with me on this one. We were supposed to do these things, but
yeah, I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them.
Yeah, Howard Music, but he failed to do it because he's no good at this shit.
That has yet to
Prosecution knows what they're doing. They're not playing
I put
around.
you on notice, and I've stated it on the record, even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got,
they have proof.
You cut it out, man. Y'all need to cut it out.
Cut it out. That's his defense. Cut it out defense. The cut it out defense.
It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced.
Gang up on me.
Gang up.
So, okay, so it went to the cut it out defense to the y'all ganging up on me defense. Okay, cool. Got it.
You sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. Had it been me, I'd have been held in contempt.
My earbuds are dying, y'all. Hold on.
Why was the bond not addressed? Why was the statement of
Sorry about
particulars
that.
not addressed? No filings that I seem to file need to be addressed.
Welcome, Leslie. Glad to
After
have you.
Sat there and told me that that's what I needed to do. Do you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there.
No, this
not
yeah,
waive
this
my right
is
to assist
almost
you
live.
of
It's
counsel.
it's a
You
couple
accepted
minutes
that.
behind, but it's live. Salty.
But you still turn around and continue to violate my Sixth Amendment right. Violate my First Amendment right by telling me what I can and can't say, which I have the right to say whatever I want to say and to be heard. That's the First Amendment.
Doesn't work that way,
Sitting up here
dude.
and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but that it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceedings. But yet still you choose to find a way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file with the Secretary of Treasury.
It's on a fucking desk.
You were asked,
what do you call
for a
those?
certified copy.
Like
Your
it's
own
on
office,
her
which
fucking
stated
bench,
on the
dude.
record
What are you
was
talking
not
about?
provided. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction, for the record. Have yet to show that you even have a license to practice law.
Wow.
Haven't proven that yet.
Wow. Yeah. So this is a big
neither has the
conspiracy.
Where's the license?
She's not even licensed.
Why cannot place your
She's not
own
even
office
licensed to practice law, people. The judge.
into the record? Why can't I make that part of evidence?
Oh my God, dude.
The oath that you haven't even honored, not one bit. Doing enough.
Oh my God.
To keep your face clean doesn't constitute being fair. Doesn't constitute being impartial. When the jury was selected, I struck the whole jury. That never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that?
Striking the whole jury. What does that mean?
To not pass a jury.
Mr. Brooks, I'm muting you. The reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
8:30 a.m. on Monday. I don't know if I'll be up that early, but yeah, I got to see where this is going. All right, so 78% of you feel that Brooks is going to take the stand. 78% of you. I think so too. I agree with you guys. I think so too. Wow. Yeah. This Judge Jenny, she has taken control. She has taken control of this trial all over again. She is a hero, people. Good for her. She's not going to quit. She's going to see this to the end. I'm in awe. This was amazing. This was amazing. Because honestly, this is one of those rare cases. No, sorry. This is the rare case where, like, you wonder, with everything that you know and with everything that you're seeing, what direction this is going to go as far as the jury goes. We know where the jury's going. We know that the jury is going to be like, yeah, guilty, done, over. But the question, at least my question, was, how is this judge going to deal with this case moving forward? That's always been my question. How is this judge going to handle this? Is she going to, like, lose control of this trial? Is he going to get a mistrial? None of that. She took absolute control. She got a hold of the ball. She got a hold of the ball, and she is gaining yards, folks. She's gaining yards, chipping away at the field and gaining yards. It's that simple. Man, yeah. Hey, I really appreciate you guys. Thank you so much for joining me tonight. I'm going to call it. It's been 6 hours. Okay. All right. I'm starting to get a buzz. And I know I'm backing out on my shit. I promised you guys. Yeah, I got that little bit of left. Yeah, it's not going to happen. I'm calling it. I love you guys so very much. And I will see you guys on Monday, meaning that we will be doing this again very soon, my friends. And you'll see me before that. Promise.